members, is to declare open the meeting, if we're all ready to go. I declare open this public hearing of the Parliamentary Joint Committee on Intelligence and Security for its review of the Counter-Terrorism Temporary Exclusion Orders Act 2019. These are public proceedings, although the committee may agree to request to have evidence heard in camera or may determine that certain evidence should be heard in camera. The hearing today is being conducted by video conference for nearly all participants. This panel format has been chosen by the committee to ensure that evidence can be obtained from the majority of submitters to the review and appropriate representative bodies, and to enable the committee to capture thematic concerns and areas for consideration. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege unless you are giving evidence from outside of Australia. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Parliament as contempt. In accordance with the committee's resolutions of 7 September 2022, this hearing will be broadcast on the Parliament's website, and the proof and official transcripts of proceedings will be published on the Parliament's website. I now welcome the representatives of the Law Council of Australia to give evidence at this public hearing today. For the Hansard record, would you each please state your full name and the capacity in which you appear before the committee?
My name, Mr. Chair, is David Neal. I'm Chair of the Law Council's Criminal Law Committee, and I appear in that capacity.
Welcome, David.
Mr. Chair, Lloyd Babb here. I'm the Chair of the Law Council's National Security Working Group.
Thank you. Welcome.
Chair. John Farrell, Senior Policy Lawyer at the Law Council.
Thank you. Although the committee does not require you to give evidence under oath, I should advise each of you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. Thank you. Would you like to kick off, or I'm not sure which one of you would like to kick off? Mr. Neal?
I'm going to start. Thanks, Mr. Chair. The Law Council of Australia welcomes this opportunity to appear before the committee as part of its review of the Counter-Terrorism Temporary Exclusion Orders Act 2019. The Law Council acknowledges the critical importance of protecting the Australian community from terrorism and national security threats. It is vital to Australia's security that law enforcement agencies are empowered to protect Australia from harm. However, a strong legislative framework relating to matters of national security does not require departure from fundamental rights and values. Australia's laws must be necessary, reasonable, and proportionate to an identified risk. The Law Council expresses serious reservations about the TEO regime and did so when it was first proposed in 2019. While the Law Council generally welcomed various parliamentary amendments made to the originating bill, which provided several additional safeguards, a number of significant issues identified by the Law Council remain outstanding. At its core, the TEO regime imposes a highly significant limitation on the fundamental right of a person to enter their country of citizenship, and consequently engages a number of rights essential to the rule of law and Australia's democracy. Given the nature and extent to which the TEO regime limits these rights, compelling evidence of its necessity and proportionality is required if the regime is to remain in force. In the Law Council's view, there is not sufficient evidence to justify this scheme in terms of practical necessity and effectiveness on the public record at the moment. The Law Council is also of the view that there are critical gaps in the statutory safeguards governing the operation of the regime established under the TEO Act. The Law Council's most critical concerns pertain to the issuance of TEOs, review rights, procedural fairness, and protections for vulnerable persons, including minors. In its submission to the current review, the Law Council made 15 recommendations for legislative improvements to the TEO regime, which seek to address the most serious of the Law Council's concerns. Recommendation 1 is directed to the foundational issue of improving transparency about the operation of the TEO regime so that its necessity can be objectively assessed and meaningfully considered. If adequate information cannot be provided publicly to substantiate the necessity of a TEO regime, questions should be asked as to whether the scheme ought to remain in force. Recommendations 2 to 15 provide specific amendments to the TEO to improve procedural safeguards with the objective of strengthening the proportionality of the TEO regime in the event that the Parliament is not persuaded that it should remain in force. Sorry, is persuaded that it should remain in force, that should be. Finally, in the committee's report of April 2019, this was instrumental in bringing about important changes to the TEO regime as originally proposed, especially in relation to legislative safeguards and oversight. The current review provides a further opportunity to reflect on the operation of the scheme, and the Law Council welcomes this chance to continue that work with the committee to strike the correct balance between national security and those rights impacted by this regime. Thank you, Mr. Chair. That concludes our opening statement, and we are happy then to respond to issues that the committee may wish to raise with us.
Thank you so much, Mr. Neal. We will open up to questions. I might start off. Your submissions indicate there is insufficient information on the public record about the operation of the TEO regime. Can you provide further information on what mechanisms you think, or the Law Council of Australia thinks, should be implemented to ensure transparency in operations?
It starts with the information about the reasons for the continued existence of the regime, the extent of its operation beyond the areas which are already covered by our national security laws. The committee will be aware, of course, of the provisions in the Criminal Code Act, which extend to very preparatory acts in relation to terrorist activities, which comprehend certainly the range of offences that someone who is engaged in fighting in a prescribed region would fall foul of. Together then with other preventive measures such as control orders, which again provide an extensive range of controls on potential security threats and are available to make any person who is in the country subject to such an order on very broad grounds. And in the circumstances of those things where a person who was fighting in one of the prescribed areas would already be committed a number of offences against the criminal code, or in relation to people who are not so engaged, that would be subject on return to control orders. The breadth of this and the overlap of it is very hard to understand and to justify, when it may well be that the person who is the subject of one of these orders is wrongly thought to have breached any of those matters. And where then the regime for quality control that the legal system would normally provide to such people who are wanting to exercise the most fundamental right of any Australian citizen, that is the right to be here, are not protected by notice of what the issue against them is, or provided with independent due process safeguards over that decision making.
So your submission, thank you. Your submission also noted that not all of the recommendations made by the committee in 2019 were adopted by the previous government. Can you be a bit more specific about the areas of reform that the Law Council would view as a priority as far as addressing any of the many of the reservations that you've mentioned?
There's quite a list of them, Mr. Chair, but it starts with the breadth of the criteria used to grant a TEO. We would want to see a thorough review of Section 10, both in 10(2)A and B, as to their breadth. Firstly, requiring some evidence that the person has engaged in conduct which would constitute either a criminal act or a terrorist act, or some convincing evidence as to why this person poses such a risk.
So just specifically, you said 10.2a, which says the minister suspects on reasonable grounds that making the order would substantially assist in one or more of the following: preventing a terrorist act, preventing training being provided, etc., etc. There's 4 subsections there. Are you saying that should be more specific?
There should be one that the person has actually done some act that would give rise to that suspicion.
So your threshold is, or the Law Council's threshold is, that there should be an actus reus, I suppose, an act actually have already been committed rather than a prevention of a potential act.
Yes, it's the eternal dilemma of predicting the future, and here the legislation itself does not require that the minister be satisfied that the person has done some act that would fall foul of the things that they then go on to say to prevent. And then the more significant problem in the following section is the 10.2b, the ASIO security threat, which is there's no parameter.
No, sorry, you cut out there. Say that again. You there, Mr. Neil? Having a few...
Perhaps if I can jump in there, there's no
Yep.
requirement or capacity to review ASIO's recommendation. The
10.2b.
yes, so 10.2b
So I was just...
submission should be removed entirely. It should be limited to 10A and in line with the UK legislation and the previous recommendation of this committee, there should be a requirement for involvement in terrorist related activities outside Australia. So
Mr. Babb, the next sort of question I was going to ask, just to drill a bit more into detail here, is that obviously there is a basis in the law around acts which, or there's an evidentiary basis, I guess, around or evidence around individuals' activities, I suppose, that there's a clear line that may lead to any of these subsections being occurring. So I understand the Law Council's points about the fact that these point out the prevention of various acts or the prevention of various activities. So preemptively, on reasonable grounds, the minister making the order on that basis. But they themselves can also be a certain level of acts as you go by degree. So obviously, based on the assessment given by ASIO and other agencies and so on, that that individual is leading up to one of those acts, I guess, is the legal basis. Is there under the law an acceptance of that kind of assessment, that those acts themselves constitute activities that may provide the reasonable grounds, or is that something the Law Council doesn't consider to be valid?
well, any evidence of the smallest preparatory act or the smallest amount of support for an overseas terrorist organisation, or considering supporting or furthering a terrorist act in Australia, would amount to an offence, as does going to an identified zone. Simply entering an identified terrorist zone amounts to an offence. So the breadth of the terrorist offences scope means that inevitably someone who is a serious risk will be caught if we add the requirement that you have participated in terrorist activity outside Australia in our submission.
Thank you. I'm not sure what's happened to Mr. Neil. It looks like his link has dropped off. Hopefully we can get him back on.
Yes.
I might now go to the deputy chair, over to the deputy chair, if you have any questions.
Yeah, I do. Thanks, Chair. Can you hear me okay?
Yep.
Great, thanks. In the absence of Mr. Neil, then I'll just assume, Mr. Babb, that you'll be able to take over in his stead.
I certainly can.
Oh, great. All right. So, Mr. Neil, and I appreciate I'm going to be asking you some questions about what Mr. Neil said, so you may have a different view, so feel free to say so if you need to. But he gave evidence just a moment ago about the utility or the necessity of the Act in the first place, and talked about the fact that control orders should be all that's required. The basis of Home Affairs' desire to want to have this legislation in place in the first instance came about, as I understand it, because of the paucity of evidence that is often obtainable in some of these countries. And if you look to the basic objects of the Act, as I understand it, it's basically to temporarily prevent an Australian from coming back to the country, to enable law enforcement to be able to effectively get all their ducks in a row, try and investigate where this person has been, the actions that they've been undertaking overseas, and to see what surveillance or other measures may be required, whilst the DPP or the CDPP may in fact be building a case against the individual. In that case, a control order may not necessarily be good enough, mightn't it? Because the TEO actually prevents the person, it buys the government time effectively. What do you say about that?
Look, I wouldn't accept that. I really think that that the answer does lie in the availability of control orders and extended supervision orders, and they can be granted on an immediate temporary basis as someone arrives back in the country. What we're talking about here is excluding a citizen from immediately being able to return. And the reality of where the citizens are awaiting return to Australia is that they're almost inevitably either going to be, if they're a male in prison-like circumstances in Syria or Iraq, or if they're a female in a camp with women and children, and when you're balancing the imposition, the taking away of this fundamental right of coming back to the country that you're a citizen of against the need, it's just not made out. I've done a lot of work in relation to control orders and extended supervision orders through my career, and they're available extremely quickly on a temporary basis when the need arises. And you can have these conditions in place quickly with the person coming back to Australia and perhaps remaining in some sort of detention-like circumstances or under extreme supervision whilst the ducks are put in a row in my submission.
So I understand your submission is that you're suggesting that in certain cases it would be appropriate for an individual to be incarcerated whilst a case is being built around their conduct. Is that correct?
Yeah. In certain circumstances, there's a reasonable ground for charging, and that would enable you to be incarcerated and detained whilst the case is built.
These things, assumedly, often take a considerable period of time in which to build those cases. Would that be fair to say?
Look, yes. If a case can be built at all, I mean, this legislation is the object was really said to be focused on not those people who have committed offences, but those people who overseas, but those people who may be supportive. It seems that to date the greater use has been on people who charged at the same time as they re-enter the country. So there may not be a case there at all, and it may be that people are excluded from the country for no good reason for a period of time.
I just wonder if the Law Council may take a different view on the incarceration of an individual back when they return back to Australia, whilst the CDPP is building a case against them. But that's probably more a statement than a question.
Sure.
Can I take you to the service issue? And I understand that the Law Council has some concerns around service of the temporary exclusion order in the first instance. But by the very nature of where some of these individuals will be, does the Law Council accept that service is going to be extremely problematic?
Yes, in some instances it might be.
Right. There is a requirement, however, on the minister to provide service of a return. Sorry, I've forgotten the re-entry permit. Because assumedly the individual wants to return and is making themselves available to Australian authorities in some way, shape or form. So service would be appropriate in that instance. Would you accept that?
Yes.
Would you accept, because we have had another submission from, I believe it was the AFP, that talked about service of the return, the re-entry permit, that should be capable of being performed by electronic means. Does the Law Council have a view on that?
Yes, David, you're back. Do you want to speak to that, or should I?
David, you're on mute.
Yeah, I've managed to overcome the technological issues of communicating with Melbourne, let alone Syria. Look, we do accept that. There are different ways in which the communications can occur in either in relation to issuing the TEO or dealing with the response to an application for a return. And the technology should be possible, and it's also possible that contact would be made with these people through relatives or the like in Australia, so that we acknowledge the technical difficulties, but the effort that should be put in. The problem we see in the bill, or sorry, in the Act as it is that the information that is required to be communicated to the people who are the subject of the order in particular fall short of anything like a proper notice of the case that's being put against them.
Chair, I've got multiple questions, and I'm just sort of conscious I'm going to take some lead from my colleagues as to whether they're happy for me to keep going or whether they want a share of the pie. You're happy for me to keep going, at least from my side? Yep. Okay.
Thumbs up from your colleagues there, Deputy Chair.
Great.
Go ahead.
Thanks, Chair. Thanks, colleagues. Either Mr. Neil or Mr. Babs, can I take you to section 10(2)(b) of the Act, which, by all accounts, it appears that there are on many sides of the equation some unhappiness or discomfort with around 10(2)(b). Mr. Neil, can you take me through some of the concerns? We've received written submissions from some of the security agencies that themselves, and in fact, it was the Inspector General for Intelligence and Security that raised some concerns around the test by which ASIO actually performs this assessment, that they have some discomfort around that 10.2b is sort of written that you could drive a truck through. Do you want to just share us your concerns around 10.2b?
Yeah. Well, look, really, you've encapsulated in it. It's vague, the vagueness of it, and the fact that the security assessment might not even be provided to the minister, let alone to the reviewing authority, where the basis for the assessment seems opaque, and and it's a bit of a mockery of the preceding section 10.2a, which attempts to go into some level of specificity. If there's a security problem with this person, by which necessity and proportion demands that such an order be issued, why can't that be specified? Not in some vaguely framed way as 10.2b. Next point is, and we make this in our submission, is that if the assessment were made through the ASIO Act, it would be subject to judicial review and merits review, but that's excluded in this Act by, don't quote me, I think it's section... Doesn't matter. It's nominated in our
Section 26, I think.
26, I think it is. Yes, thanks. Yeah. The real issue in the whole thing is that citizenship rights are absolutely fundamental, and the criteria of them being so vague means that A, the minister, B, the review authority, and C, most importantly, the person concerned, doesn't know any of the specifics. And one would be concerned in circumstances where these people are in remote and troubled areas, how accurate the information that's being received in order to make the ASIO assessment is. But there's just simply no opportunity to test these things, whether there's a case of mistaken identity or some extraordinary circumstance, or I just wasn't there at all. All of these things remain opaque in a situation where it's a one-sided application, where ASIO stands between the minister and the review authority. And even though as I said, in the ASIO Act, you would have an opportunity to review the assessment, you don't here. And then is the assessment one that does necessitate a person being excluded from the country? And wouldn't you be able to find out more information if they were brought back here and held in detention or under a control order while the other inquiries were being made? Why is it that they are being kept in a remote and dangerous region while the security agencies take risks finding out about what's going on with them? It's all too vague.
I'm not going to disagree with the vagueness of the wording around the assessment of 10.2b, but this brings us back to a more fundamental question, doesn't it? That when we talk about and using the language of the legislation itself about the paramountcy of the protection of the Australian community, and when you weigh that up against an individual's decision in most instances to leave Australia and go to a conflict zone in the first instance, there has to be a weighing up of those two competing principles, doesn't there?
There does, and there has to be evidence that supports the balance, and that's what I'm pointing to as lacking. And there's a fundamental tension between saying, well, we can't go there to serve documents on this person, but then saying we do have enough information about this person that would require their exclusion. Now, there are a number of instances of the women there who have been taken to those areas under coercion from families or people related to them. And you'd want to know that if you were wanting to, you would want to get them out of there if that's the case. How do you know that? With all of these things, the risks of seriously endangering, as was the case in Alexander, for instance, seriously endangering the person concerned versus the concern about national security, which could very conceivably be addressed by putting them, or as has happened with a couple of these people, arresting them and holding them in custody on charges when they return, if they've committed an offence, or if they've not committed any offence, but in the circumstances of the women and children, they could be subject to control orders. Here, when they can be made in-person assessments of what potential threats that they might pose here and how those threats might be dealt with.
This comes back to the Law Council's utility argument or necessity argument in the first instance, but I would go back to Home Affairs justification for the decision to want to have the bill introduced in the first place, and that is that it provides that pause opportunity to prevent the person from coming back to Australia in the first instance whilst the CDPP build their case.
Well, again, that's the bit that I guess we differ on. I understand the concern, but if you want information about the person who's an Australian citizen, having them in an area which is inaccessible doesn't help. And if you don't have enough evidence to assess them immediately and charge them, they still can be held via a control order while those assessments are being made here, where the information about them is going to be much better. And
Thank you.
We might move on if we can. Sorry, Chair. Are you right if I keep going?
Yeah, I'm just conscious of time, Deputy Chair. There are other members that wanted to ask some questions, and we've got about 10 or so minutes left with the Law Council of Australia. But why don't you go ahead and ask another question, and then we'll maybe move to the next member.
Okay, this is quite an important point, and that is the discretion as to who should make the temporary exclusion order in the first instance. So there's the tension or the question of whether it should be the minister that makes the decision, in this case at the present time the Home Affairs Minister, or whether that should actually be made by a judicial officer. Currently, the way it's currently worded, it's made by the minister. The Law Council says that it should be made by a judge of a superior court. Do you want to just talk us through a little bit about the rationale for that, please? And when you're doing so, can I get you to specific? One thing that really troubles me about the submission, I think you've also said, is that it should also be capable of being made by a senior member of the AAT, and I have some pretty grave reservations about that. Over to you.
Look, our preference would be to do as they did in the UK and put this decision in a court. It's because it deals with we do a disservice to the importance of citizenship if we allow decisions about a person's citizenship to be left in the hands of the minister of the day. It's inconsistent with dealing with rights that the legislative branch or the executive branch makes those sorts of decisions. They're decisions that should be made by courts. And the High Court's decision in Alexander just recently emphasises that in bold capitals. That is.
Yeah, I think we might have
I'll jump in again.
lost Mr. Neil again.
So we would agree, Mr. Deputy Chair, that it shouldn't be a senior member of the AAT. It should be a court. The idea for this bill was originally developed in the UK, and in the UK, it's a court that makes the decision. It gives a higher confidence in the level of independence and the necessary skills to balance the rights and the risks. And we've made a grave mistake in this country by making it an executive decision. And the review mechanism is completely insufficient. The idea that the review can be, it looks like it's pretty significant when you start off referring to a High Court judge or a Supreme Court judge, and then it gets down to a senior member of the AAT with 5 years experience. They don't even have to be a judicial member of the AAT, and they aren't reviewing all the material if the minister decides that it's not in the public interest to give them the material to review. So it's inadequate, the system, and this committee recommendation back in 2019 that it be a judicial decision wasn't followed, and it should have been, and that would put us in line with the UK. So if this legislation is necessary, then the only way that it's going to be proportionate is if it's a judicial decision.
Thanks, Mr. Babb. Thanks, Deputy Chair. We've got about 5 minutes left. If I can go to Mr. Hill, please. Over to you.
Thanks, Chair. Can I just pick up on that then? If we could just accept, for the purposes of just a few questions here, that the committee accepted that the legislation is necessary, which I think has been the previously stated position of the government and now opposition. Just to tease out what you said there, I mean, I've got this old-fashioned view that you don't make the country safer through passing legislation which is unconstitutional, which is what the former government did with the citizenship laws, parts of which were struck down, as they were told, would be the case. Are there any direct implications? Could you just tease them out on the record of the Alexander and the High Court decision for this bill?
Yes, I think there are, in relation to the way this bill's currently structured in 2 ways. Firstly, there's a very respectable argument that the minister is exercising judicial power, and that the initial decision by the minister is in breach of the Constitution, and secondly, that the review provisions, which are delegated to an individual, are also judicial powers reviewing the decision of the minister. So there are constitutional issues with the current structure, and I think that's pretty much recognised in the Act itself, which at section 30 says, in the event that the review process is struck down, then the initial decision can remain.
Right. Is that the summation, or is that all of the constitutional concerns which your members have identified with the bill at this stage, or are there other aspects that we should be contemplating or aware of?
Look, I think that because the requirement for there not to be procedural, the exclusion of a requirement for procedural fairness is problematic. In
constitutional terms or just policy terms?
Well, in policy terms, I think.
Okay, yeah. Can we? Sorry, the purpose of these questions, I'm just mindful the chair's kind of, going to move us on. I'm just really trying to get on the record the full extent of any constitutional concerns, and I'm not meaning to trivialise the 2 that you've put forward, but just wanted to clarify, are there any more?
Look, I think the ones that I've mentioned are the 2 main concerns, but in the event that we move to a judicial system, then issues like not requiring procedural fairness and not requiring reasons would then be constitutional issues. They'd be inconsistent with
Okay, that makes sense.
With a court exercising judicial power.
And so, in summary, then, what are your recommendations or suggestions for change, putting aside your policy concerns with the legislation in its entirety, which is not the stated position of the government or the opposition? What would be your recommendations for change to reduce the risk of constitutional challenge, which is a concern which we need to contemplate given the High Court in Alexander?
Yeah, the best way to deal with it is to put the decision in the hands of the judiciary. So the Minister for Home Affairs would bring an application before a court in the same way that it occurs in the United Kingdom.
Right. Would it reduce the risk, or they're not eliminated, if the decision remained with the minister, but you made some improvements to the process around requiring the ASIO assessment to be there? You've suggested some review rights for the ASIO assessment and/or adjusting the judicial review. Would that normalise it, do you think?
I don't think it would remove the constitutional concerns.
Final question. I'm just sort of exploring, because there's a number of options we could think about. Do you think it would be more likely to be acceptable if the minister retained a sort of an urgent power to intervene and act, and then have a more normalised process?
Yes, I think we say in our submission that extreme urgency could be met by allowing the minister the power to impose an interim order, but that it would lapse if it wasn't immediately brought before a court and the court made its own decision about whether an order should be made.
I'll leave it there, Chair. I think we've got a lot of very helpful written material on other issues that we haven't got time to tease out right now.
Thank you so much, Mr. Hill. Colleagues, we've got a couple of minutes left with the Law Council of Australia. Any questions from members? I'm looking.
I've got some more questions. If I know, Karen, go.
Yeah. Karen, would you like to proceed?
Yes, I will then just be super quick, and Andrew Wallace, I'm happy for you to take some more of the time that I may have had. So just in regard to the last point that was made in relation to a potential power for the minister to make an interim order, does the Law Council have a view on the time frame for that? So what would be the length of time that you would be proposing?
There would be a very short time frame. It'd be along the lines of other interim administrative decisions in the criminal law. So you may not put an hour or day limit on it, but you would require it to be brought before a court as soon as practicable. David, you may have more to add.
No, I agree with that. And it's in the nature of urgent control orders, and there are models for that already in the Criminal Code Act surrounding control orders. So and courts are used to dealing with those sorts of situations, so that the minister's action would be a holding operation until it could be brought before a court. But I would have thought that as soon as practicable, 7 or 14 days would probably be the sorts of. I can't now remember what the provisions in the Control Order Act says, but there are models for all that sort of thing there.
Any further questions, Miss Andrews?
No, I'll leave it at that. Thanks. But if Andrew had some more.
Deputy Chair, did you have another question? We've probably got time for one more, I think.
Yeah, we've got 5 minutes. We've got all the time in the world, Chair. So
no, we've got 45. We're done. All councils on borrowed time.
Mr. Neil or Mr. Babs, can you just give us a bit of an understanding as to the UK provisions in their legislation about when an application is brought to the court? An interim order may be made, or the minister may in fact be able to make an interim order. But what's the effect of that in the UK legislation? That interim order, is that something that has a sunset clause on it that has to be revisited on a regular basis, and whilst the process is working its way through? How does it work?
Speaking myself, I'm not sure. We might need to take that on notice. I'm sure we can find that out very easily. I just don't have that at my fingertips unless either Lloyd or John does.
I've just got John checking it. He's got the UK.
While you're doing that, can I just ask another question?
We can get back to you on that,
Thanks, Mr. Neil. Can I just ask another question? It just goes to the constitutionality of the people who are undertaking the in the current state of play with the review process that enables a retired judge. How does a retired judge's position go in relation to the constitutionality of it, as opposed to a sitting judge?
That's a good question, and I think it's dubious because they're not really a court, and that's what the constitutional requirement is. And that recent case of Alexander is not exactly analogous with this one, but there are strong analogies there. Firstly, the court was concerned with the liberty of the individual and protecting that and the seriousness of the interference. There's secondly a question there about whether what's being done is tainted because of its punishment. But certainly the court was saying that when you are dealing with citizenship rights, the separation of powers arguments are attracted. It would be a nice question to ask the High Court about, but certainly there are things in that decision in Alexander which would suggest that the current situation with either the minister or the review authority would be vulnerable to a challenge.
Yep. No,
The persona designata device, I'm not sure what the High Courts would say about that, but given that it's not a court, I think it may too be vulnerable.
And the AAT issue has been put to bed, hasn't it? Because if I remember back to my administrative law days in several lifetimes ago, the AAT is considered not to be a court of record. So that would also pose constitutional issues, wouldn't it?
Look, I'm not as sure about that, but the other reasons that you raised earlier about the desirability of the AAT dealing with this issue, unless it's that specialised division, it's problematic. We would rather see it put in the court.
Mr. Babs?
Yeah, I've got nothing further to add.
Oh. Thanks, Chair.
Thank you, Deputy Chair, and thank you, Mr. Neil, Mr. Babs, and Mr. Farrell for your attendance today. If you have been asked to provide any additional information in the course of our discussions today, please do forward it to the Secretariat by 4 p.m. Monday, the 24th of October this year. You'll be sent a copy of the transcript of your evidence. Just wanted to make that clear, Mr. Neil. You'll be sent a copy of the transcript of your evidence and will have an opportunity to request corrections to transcription errors. Thank you very much for your attendance. Much appreciated.
Thank you for the opportunity, Mr. Chair, and the committee.
Thank you.
And I think we do, colleagues, have the next set of witnesses ready to go, and that's the Australian Human Rights Commission. Is that right, Secretary?
Chair?
Yes. They're just getting set up. Let us know. I think they're ready to go. Right. Oh, very loud mic. You can just put it on mute. Just for the moment. Thank you. Welcome. I now welcome the representatives of the Australian Human Rights Commission members who are with us today to give evidence at this public hearing today. For the Hansard record, would you each please state your full name and the capacity in which you appear before the committee?
Well, good morning. My name's Lorraine Finlay and I appear today as the Human Rights Commissioner on behalf of the Australian Human Rights Commission.
Good morning, Chair. My name's Graham Edgerton. I'm the Deputy General Counsel of the Australian Human Rights Commission.
Thank you, Ms. Finlay and Mr. Edgerton, for appearing today. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of Parliament. and therefore has the same standing as proceedings of the respective houses, the giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I might ask you, Ms Finlay, to if you have an opening statement to proceed.
Well, thank you, Chair, and thank you to the members of the committee for inviting us to provide evidence here today. I would like to open simply by emphasising the initial remarks made by the Law Council of Australia in their opening statement regarding, obviously, the importance of ensuring the safety and security of the Australian people, but the need at all times to balance that with a framework that protects fundamental human rights. And that's fundamentally the key question that's before us when we're considering the Counter-Terrorism Temporary Exclusion Orders Act 2019. When this Act was first passed in 2019, it was made subject to a mandatory review by this committee within 3 years. Such a review is appropriate and timely for 3 reasons. First, the people to whom the Act is directed in practice are different from the people the government indicated that the Act would apply to when it was first passed. Secondly, the number of people potentially affected by the Act has progressively declined over the last 3 years. Thirdly, it has become clear that there are alternative mechanisms available to keep Australians safe, which mean that, in our view, this Act is no longer necessary. The Act was initially directed at foreign fighters who had travelled to conflict zones in Syria and Iraq in order to provide support to extremist groups. However, the Australian Federal Police have since confirmed that the regime is not necessary in relation to people who were active fighters. This is because they will be subject to arrest warrants and could be immediately detained pursuant to those warrants once they return to Australia. According to the AFP, the object of the TO regime has changed to focus on associates and facilitators and relatives who are not themselves active fighters. The number of those people has steadily declined over time. Figures published by the Insulam suggest that there are now only around 60 Australians who have travelled to the conflict zone who have not either already returned home or been killed. At the end of 2019, there were 40 active arrest warrants in force in relation to alleged foreign fighters. That leaves only 20 Australians who travelled to the conflict zone that the TO regime could apply to in practice. It appears that most of these will be women detained in the Roj and Al-Hol camps in northeastern Syria. It has been reported that the Australian government is considering bringing these women and children back to Australia. The TO regime is not necessary for this purpose. According to media reports, there are 16 Australian women in the Roj camp and 9 of them could be charged with an offence under section 119.2 of the Criminal Code of being present in a declared area in Syria. Media reports suggest that all 16 of these women would consent to control orders under Division 104 of the Criminal Code being made in relation to them if they were returned to Australia. In those circumstances, there is, in our view, no need for a temporary exclusion order to be made in relation to any of them. Further, if Australian authorities suspected on reasonable grounds that any of these returnees had committed a terrorism offence or were preparing to do so, they could be arrested immediately on their return to Australia and questioned in relation to those suspicions. Further action could then be taken if those suspicions were confirmed. The Commission's primary position is that the TO regime should be repealed because it is not necessary. In the alternative, we've made a number of recommendations to ensure that the regime is more proportionate to its purpose. First, the regime should be limited to people who have been involved in terrorism-related activities outside Australia. Australian citizens who are not themselves involved in terrorism should not be prevented from returning to Australia. Secondly, any exclusion order should be made by a court and not by the Minister. Thirdly, if the Minister retains the ability to make an order in urgent circumstances, then the Minister should be required to obtain the approval of an independent issuing authority as soon as practicable thereafter. Fourthly, any temporary exclusion order should include a summary of the grounds on which it is made, excluding any national security information, and a description of the person's review rights. Fifthly, temporary exclusion orders should not be available in relation to children, or, at a minimum, the best interests of any child affected should be a primary consideration in the making of such an order. And sixthly, a person should not be prosecuted for breaching a temporary exclusion order or the conditions of a return permit unless they knew that the order or return permit was in force. Our written submissions provide more details in relation to each of those recommendations. Thank you again for the opportunity to be here this morning providing evidence to the committee, and we're happy to take any questions relating to our submission.
Thank you very much, Ms Finlayson. I might start off by obviously you've outlined in your submission and your opening statement your primary position that that the Act should be repealed based on your submission. But if it wasn't appealed, there's a series of reforms that you think important. Just to go back to the first part, though, the part of your opening statement which reflected on the fact that the need for the Act is no longer there, given the numbers that you outlined with respect to the foreign fighters and the Australians that would be subject to it. But technically speaking, I guess, setting aside the critique of the Act here or there, the Act could apply to an Australian that might be in Europe or some other part of the world who falls under the 10A and 10.1A and 10.2B, for example. Would that be correct?
Potentially it would be able to, and yet it's important to note that when the Act was introduced, it was done in relation to specific events and specific concerns. And given the extraordinary powers that are available under the Act, it is important to think about its possible applications and, in our view, to look at it within its context of the broader framework in which it applies.
Yeah. No, I think that's right. And obviously the genesis was very much linked to a specific areas of concern, but I just wanted to be clear that the Act obviously does apply to other parts of the world. The next question I have was really around the, in your view, if you could just turn the question over there, I think it might be where you are. Yeah, thank you. The space in which you think there should be reforms, what would you recommend in relation to matters the minister must, if the minister retains that power, the minister would reasonably suspect before they make a temporary exclusion order? What would they have to go through? How would you change those sections of the Act?
In terms of the threshold that would apply, Chair?
Yes.
That's recommendation number 2 in relation to our submissions, and it mirrors the former recommendation made by this committee in its 2019 report. So we would say primarily that there needs to be limited to people who've been involved in terrorism-related activities outside of Australia, and that would be the primary criteria if you have a look at section 10A. And secondly, that the making of the order would substantially assist in preventing the provision of support for or the facilitation of the Terrorist Act. So there are those 2 criteria. And then our submission would also be that the current section 10.2B should be repealed.
So just on with your respect to your submission on 10A, because this was a discussion about this with the Law Council of Australia, there could be evidence pertaining to an individual being involved in terrorism-related activity, but not necessarily an act being occurring yet, but a certain presumption that the act, or there's a certain number of activities leading up to a potential act, and the evidence itself could be circumstantial, but certainly could trigger off 10A. Are you, just to be clear, your recommendation is saying terrorism-related activity. How is that different from the subsections of 10A which talk about a prevention of a terrorist act, prevention of facilitation of an act, of support for a terrorist organisation, and so on and so forth for all of the subsections down to number Roman numeral 4?
I think the key difference, Chair, is that the current 10.2A refers to the Minister suspects on reasonable ground that making the order would substantially assist in one of the following, which includes preventing a terrorist act, whereas on our recommendation the requirement would be that the Minister reasonably suspects that the person is or has been involved in terrorism-related activities.
Right.
So it's a more direct link to the person's actions.
Yes. So really raising your recommendation is really raising the threshold more towards a direct correlation between that individual and the acts that are about to be committed, for example.
That's correct.
Potentially. based on the
And Chair,
evidence.
if I could expand on
Rather
that,
than, yeah,
as you say, it's really about tying the risk to the individual that the TEO would apply to. So it's not just this person might be able to give evidence in relation to a risk posed by someone else. There has to be a reasonable suspicion that the person themselves who would be subject to the TEO is themselves at risk of committing a terrorist act.
right. So a person who has knowledge of plans, for example, towards a terrorist act, who may be in the room when these potential, acts are being discussed, or the planning, or even issues around planning for training or potential training, or even financing and so on and so forth. That individual just having the knowledge of that, being in the room when that's discussed, is not enough to trigger the threshold, your threshold, as you've recommended.
It wouldn't be, but preparatory acts for a terrorism offence are themselves an offence under the Criminal Code. So if that person was actively participating in preparing for a terrorism act, that would be an offence under the Criminal Code, and potentially.
Yes, but actively,
apply to.
Actively is a bit different than being in the room and hearing some of this stuff go on. That's a bit different.
Although, having said that, Chair, the offences are broad enough in Australia, for example, that travelling to a declared area is in itself enough. So if you were in the room in one of those areas, that would be enough to bring you certainly under the criminal offences within Australia. So again, it's a matter of putting this in the context of the broader regime that applies to ensure the protection of the Australian community.
Yeah, so just your recommendations really are raising that threshold, tightening it up effectively, and they are very similar to what the committee has recommended in our, or the previous committee. I wasn't on it at the time, but in our recommendations on this back then. Thank you very much. I might just, for the sake of time, move on to the Deputy Chair and also allow other members to ask questions. I go to you first, Deputy Chair.
Thanks, Chair. Thank you for your evidence, Ms Findlay. Can I take you to your second point around your concerns that the Act isn't actually catering for or dealing with the people that it was intended for? What's your evidence for that statement?
Well, Deputy Chair, it's what I outlined in my opening statement, which is that when the Act was originally enacted, it was said to be directed at foreign fighters who had travelled to conflict zones, and yet the AFP have provided that the TO regime's changed focus so that now it's really associates and facilitators and relatives who weren't themselves active fighters who will be the people who come within the scope of this Act. Noting, of course, that the people who were active fighters can indeed be dealt with through other means.
But do you concede that the Act itself doesn't limit itself to the actions of foreign fighters?
Of course, but we would also put that the Act shouldn't be considered in isolation, and we actually should look at all of the mechanisms that are available to the Australian government to keep the Australian community safe. And in our view, this particular Act isn't the mechanism that will in practice be applied to those active fighters, and therefore it isn't the best mechanism in that regard.
Right. And this comes back to, I don't know whether you heard the evidence and my questioning of the Law Council in relation to whether these things are best dealt with by way of control orders or otherwise. What's your view in relation to the concerns that this Act fills a gap that control orders can't, because this Act provides the Australian government time, it buys the Australian government time, to investigate the activities of the individual whilst that person is held offshore, and B, it provides the Australian government time to, when the person does return to shore, whether that's by way of a revocation of the TEO or by way of a return permit, that it buys the Australian agencies appropriate time to put in place whatever arrangements may be required to ensure the safety of Australian citizens.
Well, we certainly acknowledge those concerns, but we would say that it really is a matter of striking the correct balance between ensuring the protection of the Australian community, but also ensuring that we protect and uphold those fundamental rights that really are the basis of the Australian community. And in relation again to the overall framework, we would say with respect to the active fighters, the AFP have already made clear that they would not be dealing with those individuals under the TO regime. They'd be looking at arrest warrants and the like. And in relation to the remaining people in those camps, we would say there are other mechanisms available of which control orders are a key consideration.
But that's my entire point, though, is that if the AFP have evidence that a person has been a foreign fighter, then they could be arrested on their return into Australia. But where the TEOs come into their own is that it buys the Australian government and security agencies the opportunity to conduct those investigations, which by their very nature would be quite exhaustive and quite difficult, one would think, to undertake given the circumstances where these people might be.
Certainly, and we would simply reflect on looking at the number of the orders that have been used and the way the legislation has been used over the last few years. We're not sure, or in our view, the balance isn't struck to the point that you're making. We would simply say that, in our view, the mechanisms of terrorism offences that exist under Australian laws, when combined with control orders, is sufficient to provide the protection that you refer to, and sufficient to provide interim opportunities to ensure that there is protection for the Australian public, while still balancing out the fact that ultimately we're talking about Australian citizens, and the right to return to Australia is a fundamental human right.
And that right is not negated as such. These are temporary exclusion orders. In fact, someone who is the subject of a temporary exclusion order can make an application for a return permit, and the Minister for Home Affairs must, under the legislation, provide that permit. It's not a question of the competing considerations. The Home Affairs Minister must provide that permit. So the Act doesn't provide for an exclusion or a derogation of that fundamental human right, does it?
Well, it certainly doesn't remove the right permanently, you're correct, Deputy Chair, but it does provide for a significant limitation of the right, and in that case, any limitation would need to be both justified, necessary and proportionate. And so it does come down to a question of that balance. And as we outlined in my opening statement, but also in more detail in our written submissions, in our view, when you look at the entirety of the framework that's available within Australia, we don't believe that the TO regime is necessary to provide the level of protection that the Australian community needs.
And in terms of the exclusion from Australia, sorry to cut across you, Senator.
No, you're right.
One of the conditions that can be imposed on that return permit is an exclusion from Australia for a period of 12 months. So it's true that a person who receives a temporary exclusion order can immediately request a return permit, but one of the conditions that can be imposed on that return permit is an exclusion for 12 months, for up to 12 months. Picking up on what the Commissioner has said as well about the gap, obviously people who are foreign fighters can have warrants issued and be extradited from other countries. You've pointed to security agencies.
In which case that 12-month rule doesn't apply.
That's right.
Someone's the subject of an extradition order.
That's right. And so if authorities don't have enough evidence to be able to prosecute someone for an offence, we say that there are two other mechanisms that fill the gap. As the Commissioner has said, control orders is one, which is a much lower threshold, a reasonable suspicion that issuing the control order will assist in preventing a terrorist act from occurring. Or alternatively, if someone has returned to Australia and authorities have a reasonable suspicion that they've engaged in a criminal act, which might be a preparatory criminal act, they can be both arrested and also questioned after being arrested under that regime under Part 1C of the Crimes Act. So it might be that authorities can get their further ducks in a row in Australia.
Can I take you to the issue of children? Now, it's the Human Rights Commission position that the Act shouldn't apply to persons between the age of 14 and 17. That's correct, isn't it?
Yes. Well, not that it shouldn't apply, but that if I can take you to our recommendation in relation to that we should be guided by our obligations under the Conventions on the Rights of the Child and ensure that, well, if it does apply to children of that age, that their interests are the primary consideration. So our initial position would be that it shouldn't apply, but in the alternative, that we should at a minimum be guided by our obligations under the Conventions on the Rights of the Child.
Okay, I'm not sure how that was different to the proposition I put to you, but I won't quibble with you on it. All right. Just in relation to the issue of the who should be the issuing authority of the TEO, your position is that that should be made by a judge. You also talk about that it could be made by a senior member of the AAT. You may have heard me express some concerns around that point with the Law Council. Do you have any concerns about that decision being made by a senior member of the AAT as opposed to a judge of a superior court?
Well, that is our alternative proposition, Deputy Chair. So our primary position, as you noted under recommendation 3 in our written submissions, is that it should be made by a court. In the alternative, if that recommendation isn't accepted, then we would submit that it should be amended to allow the issuing authority to be a judge, a retired judge, or a senior member of the Administrative Appeals Tribunal. So we certainly do take your point, and that's why our primary submission would be that it should be done through the courts.
Nevertheless, it's still a secondary position, and
yes.
I'm keen to probe you on the constitutionality of the retired judge issue or the senior member of the AAT issue, putting aside the merits of whether it's appropriate for someone with as minimum as a 5-year experience post-admission should be making these sorts of decisions. Looking at the constitutionality of that point, have you considered that?
Only insofar as to recognise that there are constitutional concerns, and we were here for the evidence given by the Law Council of Australia, and certainly do recognise the constitutional issues that were raised during that discussion arising out of the decision in Alexander, and we would say that is something that should be considered by this committee.
And probably the best way of addressing those constitutional issues would be to have the orders issued by a court in the first place, and to remove the review mechanism that's currently in the bill that allows a review by bodies that are not courts.
And adding, of course, that difficulties that relate to a senior member of the Administrative Appeals Tribunal issuing orders also then would relate to a minister issuing those orders. So it is really a question of an executive authority versus a judicial authority and where the appropriate power should lie.
So I know I'm bouncing around a little bit here, but I want to take you back to section 10, subsection 3, which is the whole paramountcy versus primacy issue in relation to children. The way it's currently drafted is that the protection of the community is paramount, and your evidence is that the protection or the rights of the child should be paramount. Is that correct?
Not quite. We say that the best interests of the child should be a primary consideration, and even though the words primary consideration are in the Act at the moment, effectively it's a secondary consideration because the protection of the community is seen to be paramount. We would say that protection of the community and the best interests of the child, where it's an order in relation to a child, should both be primary considerations, and one should not be seen to be inherently more significant than the other.
I'm really quite bemused by that comment, though, because if you accept as a matter of principle that a young person between the age of 14 and 17 is just as capable of committing an act of terrorism than someone is 18 plus, why should the protection of the Australian community be somehow second to the rights of the child just because they're under 18?
That isn't our position, Deputy Chair. It's not that the protection of the Australian community would ever be secondary to any other consideration. It's simply that acknowledging the rights of a child are given particular consideration under law and under Australia's international obligations. We would simply say the interests of the child in those circumstances should be a primary consideration alongside with the protection of the Australian community. And our view of the legislation as it currently is that that isn't the case, and that the rights of the child effectively are a secondary consideration.
Yes, I'm not arguing with your understanding of what the legislation provides for. I don't quite understand how you can have two primary positions, as in the protection of the community should be primary and the protection of the child should be primary. One has to take some sort of precedence over the other, you would think.
Well, we would say that they could both be primary considerations, Deputy Chair, and that certainly under the Convention on the Rights of the Child, Australia's international obligation is to actually do just that.
Okay. All right. Can I...
Deputy Chair, do you have further questions, Deputy Chair? I was just noting we're just running out of time for other members to ask some questions.
I'm guided by you, Chair. I'm in your hands.
That was very kind of you, Deputy Chair. I might just go to, I understand that Mr. has some questions, but if others have questions, please put your hand up so I can
Peter.
as well. So I might just go to Mr. Hill first and then Casey.
No, maybe go to Andrew, because my questions were about the rights of the child, and I think they've been well covered by
Mr.
the Deputy
Wallace.
Chair. If we get a moment, it'd be good to explore 7.5 in the submission, the mental element for offences. But happy to go to Andrew first.
Great, thanks, Mr. Hill. Mr. Hasey, you've got the floor.
Thanks, Chair. Hi, Ms. Finlay. Good to see you again. Mine's a philosophical question, and it goes to recommendation 3 about a Superior Court issuing the temporary exclusion order. And I asked the question in the larger context of the public debate around the National Anti-Corruption Commission. Several members of this committee have already come out and said that the AAT shouldn't be issuing covert or overt warrants. Can you just go into give us a statement as to why it's important that a Superior Court be the arbiter of the TEOs or warrants across a number of different acts?
Well, thank you, Mr. Hasty. It's a very good question in terms of highlighting the fact that the human rights that we're talking about don't apply solely in exclusive context, but instead we do need to consider them in a wide range of contexts and be consistent in the way that we apply these principles. And in terms of the separation of powers and ensuring that there is due process and procedural fairness in the way that we look at limiting or removing fundamental rights and freedoms, we would say there is a clear importance attached to having judicial authorities overseeing those arrangements and to ensuring that the courts are there to provide assurances to the Australian public that their rights won't be limited other than according to law.
Thank you.
Chair, just a very quick
Hasty, Senator Patterson. Senator Patterson.
As a matter of principle, what is distinctive about the AAT that makes you think that it's not the right body for these sorts of decisions?
Well, I should first of all simply emphasise, Senator Patterson, that we're not by any means impugning the integrity of the AAT or the excellent work that that body does, but it isn't a Chapter 3 court, and therefore it doesn't have those same protections that a Chapter 3 court can offer, and doesn't have the same significance of a Chapter 3 court as under the Australian Constitution.
Yes, and perhaps we could say another point is that AAT members have fixed term appointments and often seek to be reappointed, and that may be a factor in their decision making.
Well, and that's certainly been a factor that's been highlighted by the courts in their consideration of separation of powers issues as one of the reasons for that separation being so important.
Thank you.
Welcome, Senator Smith and Senator Ciccone. Do either of you have a question?
Not for these witnesses. Thank you, Chair.
Thanks, Senator Smith. Are there any further questions from members?
Yeah, I'll go to 7.
Mr. Hill, you wanted to come to...
Yeah.
Section 7.
Keep myself nice for the morning and not state the obvious about the AAT. Just in relation to 7.5, the mental elements for offences, actual knowledge. Can you just briefly take us through that? Because I was interested to note, I wasn't on the previous committee, that the PJCIS last term had a view, as you outlined in paragraph 100, but the previous government didn't accept that recommendation, but did note that this review would be an opportunity to return to it. Could you just summarise the issue and your recommendation?
Certainly. So the issue relates to the knowledge that an individual needs to have in order for the mental element of these offences to be made out in relation to a TO applying to them and a breach of the terms of a TO. And our recommendation, which I may refer the committee to recommendation 8 of our submission, and it's dealt with in pages 22 through to 24 in detail. The essential submission is that the TO Act should be amended so that actual knowledge is required. That is, that a defendant must be shown to have had knowledge of the existence of the temporary exclusion order or of the relevant return permit condition as applicable. And in our view, this goes back to the conversation or the discussion that this committee was having with the Law Council of Australia regarding the service of TOs on individuals who are often in places that are difficult to access. And in our view, a way of working around those challenges is to focus instead on the knowledge required to prosecute somebody for a breach of the TO. So actually a better way of dealing with that situation would be to put in place an actual knowledge requirement. I don't know, Mr. Edgerton, if you wanted to add anything to that?
No, I think that that's covered. I mean, essentially, a TEO or a return permit could be issued in circumstances where the person, the subject of that order or permit, does not know that it's been issued. It can be difficult to serve people. There should be some flexibility on issuing authorities in that service, but by the same token, people should not have criminal sanctions imposed on them if they don't know that they're subject to those requirements.
Did you have any views on what's acceptable service?
None that we formalised in our recommendation, as again we think a more practical way of dealing with the issues that arise in that. We accept there will need to be a degree of flexibility in terms of service, but we think the result of that is there does need to be that higher requirement of knowledge in relation to the application of criminal sanctions.
Yeah, it's pretty hard to establish actual knowledge in these kind of situations, is it not?
We would say that it's a commonly used legal term, and while certainly it does impose a higher requirement, given the nature of the offence and the consequences of being convicted of that offence, we say it's appropriate.
Well, I suppose my final question, I wouldn't in any way claim to have ever been the best criminal law student, but the criminal law applies. I mean, everyone's subject to the criminal law, whether you know you're committing an offence or not, as I vaguely recall from last millennium.
Correct, as a general principle. However, there are some offences where actual knowledge is required,
right.
And we would say the nature of this offence would be such that that's appropriate.
Okay, but it would still be open to a court, as currently drafted, to take into account actual knowledge in determining penalty or so on, would it not?
To determine penalty, certainly, but not in terms of determining whether the offence itself has been committed.
Yeah, okay. All right, I take your point there. All right, thanks, Chair.
Thank you, Mr. Hill. Any further questions, colleagues?
Peter, I just wanted to one
Senator,
question.
go ahead.
Thank you. Look, just following on from the earlier conversations around temporary orders, I am curious, though, to get your thoughts around, in the cases of where there may be an urgency or an urgent matter, whether the executive should still be vested with that power of issuing a TEO, and if so, what would be your thoughts around, I guess, the safeguards around that, given that the executive was still able to issue a TEO?
So that does take you, Senator, directly to our recommendation number 4, and we do provide in that recommendation that in respect of urgent situations, a minister may issue a temporary exclusion order or impose a condition in a return permit without requiring the approval of an issuing authority. But the safeguard we would seek to have imposed is that the minister should then be required to obtain that approval as soon as reasonably practicable, and if that approval was not obtained, then the order must be immediately revoked.
I guess my central question does go around the safeguards. Are there any other safeguards that you'd like to see built into the system, apart from the ones that we've sort of touched on earlier? Are there other systems around the world that you might think we should also look at as well too?
Well, I think the other safeguards are all outlined in our written submissions. The primary one would be lifting the initial threshold in terms of when the orders can actually be made in the first place, and that's the Section 10 criteria. We would say then the safeguard of having the orders issued through the courts would be another important safeguard, but we do recognise there may be those urgent situations, and the safeguard that we would see as being primary there is the requirement that as soon as reasonably practicable, the matter be brought before an issuing authority.
And if we're thinking about comparative regimes, those safeguards are present in the UK regime.
Okay. All right. And in terms of the authority, who would guide, I guess, or decisions on approving an independent authority? Who should be the responsible authority to make those appointments?
I'm sorry, Senator, could you repeat the question?
The appointments to such an independent authority, who should be, I guess, have the authority to make those appointments? Be still the executive?
Well, our primary submission is that the issuing authority should be a court, and that an application should be made to a court for these orders, and those appointments are made through the usual way that judicial appointments are made.
Okay, so the individuals appointed to such an authority be done through the Parliament, or appointments by the Executive and Council?
Well, our submission is that the order should be made by the courts, so that would mean that the judges who are appointed in the usual way.
Okay. Thanks, Pete.
Thank you,
Chair. Can I just ask a quick question, please?
Sure, Deputy Chair. Go ahead.
Just in relation to the issue of, your submission is that the issuing authority should be the court on application by the minister. Can you envisage a circumstance where, and I'm playing devil's advocate a little bit here, but that assuming the minister is on top of his or her brief, they may be aware of circumstances which go beyond the particular relevant individual where the application is being sought for, where a judicial officer is likely to be constrained purely to the evidence in relation to that individual. That is a situation that speaks against the judicial aspect, that in some cases it may be preferable that the decision be made by a minister who is likely to be briefed in all of the, one would hope, the classified material in relation to not just that individual, but perhaps associates, etc.
I'd answer that in a number of ways, Deputy Chair. The first would be to note again that this regime does not sit in isolation. So if the minister was aware of that type of information, there would potentially be, for example, opportunities to charge for offences, including preparatory offences under the Criminal Code. There would also be an opportunity for the control orders regime to be invoked. But the second point, and it's perhaps more philosophical, that I would raise is that if we're talking about a significant restriction of the right of an Australian citizen to return to Australia, or a limitation of that right, the suggestion that that should be based on available evidence, should be subject to review, and should be a constrained power is something that, in my view, is very important. And the idea that an order of that significance could be made on evidence that isn't reviewable and that isn't available and that isn't able to be tested is something that is deeply problematic. So while there may be circumstances such as those you've outlined, we would say firstly there are other avenues for the protection of the Australian community to be assured, but secondly, that we need to ensure that those powers would be very tightly regulated and sparingly used, because the situation you're talking about is quite an extraordinary one.
All right, thanks very much. Thanks, Chair.
Thank you, Deputy Chair. Thank you so much. Are there any questions, colleagues? That being the case, I do want to thank you, Ms. Finlay and Egerton, for your attendance today. And if you, in the course of these hearings, provide any additional information, could you please forward that information to the Secretariat by 4 p.m. on Monday, the 24th of October, 2022. You'll be sent a copy of the transcript of your evidence. We'll need to request corrections to transcription errors if there are any. Once again, thank you so much for your taking the time to appear before the committee.
Thank you very much.
Thank you.
Thank you. Colleagues, we're just going to go to a 15-minute break. When we come back at 11:45, we will be hearing from the Inspector General of Intelligence and Security, Christopher Jessup. So I will see you all in 15. Thank you. Welcome, Mr. Jessup, and thank you and your representatives from the IGES for being here to give evidence at this public hearing today. For the Hansard record, would you each, I've named you, but could you please just state your full name and the capacity in which you appear before the committee?
Yes, thank you, Chair. My name is Chris Jessup, and I am the Inspector General of Intelligence and Security.
Good morning, Chair. My name's Chris Brooks. I'm the Assistant Inspector General, Agency Oversight at Inspector General of Intelligence and Security.
Thank you, Mr. Jessup and Mr. Brooks. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as contempt of Parliament. Given today will be recorded by Hansard and attracts parliamentary privilege. Mr. Jessup, would you want to make an opening statement, or should we go, or do you want to do that before we go into some questions?
Do you want to provide an opening statement? Yes, well, I thank the committee for inviting us to appear at today's public hearing, and I do have a short opening statement.
Thank you.
As our submission notes, my office's interest in the committee's review of the Counter-Terrorism Temporary Exclusion Orders Act is as the agency responsible for oversight of ASIO's activities. ASIO's role in the TEO regime is small but significant. The TEO Act provides two alternative circumstances under which the Minister may make a TEO. First, where he or she suspects on reasonable grounds that one of the thresholds in paragraph 10.2a has been met in relation to a person, or secondly, under paragraph 10.2b, where the person has been assessed by ASIO to be directly or indirectly a risk to security for reasons related to politically motivated violence within the meaning of the ASIO Act. My office's jurisdiction relates primarily to the second of these circumstances. Although my office does not review the decisions of ministers or the activities of the Department of Home Affairs in administering the TEO Act, we do oversee ASIO's provision of advice to the Minister and the Department, in particular where an assessment has been made under paragraph 10.2b. My office has conducted several inspections of ASIO's activities under the TEO regime to date. We have included comments on the findings of these inspections in our annual reports. And I note in that context that our annual report for the year recently ended has not yet been published, but is that publication is imminent. Informed by our inspection activities, our written submission makes 4 broad observations about the practical operation of paragraph 10.2b of the TEO Act, including some matters where we think greater clarity and statutory guidance would assist oversight. These matters largely arise because of the unique nature of the assessments made by ASIO for the purpose of paragraph 10.2b of the TEO Act. As the Act makes clear, these are not security assessments for the purposes of Part 4 of the ASIO Act. However, due to their statutory effect, they are also different from ordinary communications that ASIO may make to ministers and departments in relation to other counter-terrorism frameworks. In accordance with existing practice, we do not express a view on policy matters, including in relation to how the matters raised in our submission would best be addressed. But we have highlighted these matters for the committee's consideration to assist your review of the Act. I would be happy to answer any questions the committee may have.
Chair, I think you're on mute.
Ada, you're on mute.
All right. Can you hear me now?
Chair,
Thank you, Mr. Jessup.
since I completed my statement, everything that you said was not audible here in Parliament House, so I don't know what it was.
I'll start again because I was on mute. Can you hear me now?
Yes, Chair.
I can hear you, yes.
Great. Yeah, excellent. I thank you for your opening statement. I might start off with a few questions. Do you think there are any opportunities IGES oversight of this particular legislation where it can be improved or where it would be beneficial?
I think the key thing that would be of benefit to us from an oversight point of view would be to clarify the procedural fairness aspect under 10.2b. The unusual aspect of the legislation in its present form is that it is clear that the minister does not have to accord procedural fairness in making his or her decision under Section 10. It is also tolerably clear that in decisions in the normal run of ASIO's work that affect a member of the public, including a citizen, ASIO is under an obligation to provide procedural fairness, although because of the highly sensitive and high security nature of most of ASIO's work, the content of that requirement will of course be variable. But what we've got under Section 10, as we pointed out in our submission, is the ultimate decision being made by the minister, but only under paragraph A of subsection 2 is the minister himself or herself required to decide whether the particular threshold has been crossed. Under paragraph B, the assessment as such is the criterion which permits the minister to make the order. Now, of course, the minister has a discretion because the order is made under subsection 1, but the actual criterion under 2B, once an assessment is made by ASIO, that is, as it were, a factum, which enlivens the power to make the order. Now, the expression security assessment is used in 10.2b, but it's not a security assessment within the meaning of the ASIO Act. So the ASIO Act itself has, as the committee will be aware, a range of mechanisms for reviewing ASIO security assessment, chiefly within Part 4A, the review by the AAT. But whilst the Minister's compliance with natural justice has been excluded, the Act says nothing about whether ASIO has to provide natural justice, and the normal review procedures are not available. From an oversight point of view, this leaves my inspection officers in the position of, yes, they can go to ASIO, yes, they can get access to all the material that ASIO looked at in making that assessment. They cannot, consistently with their remit, because these inspections are made under the IGES Act, not under the TEO Act, they cannot go beyond looking at questions of legality and propriety. They would normally regard a failure to provide procedural fairness on the part of an agency that was obliged to provide procedural fairness as a matter which goes at least to propriety and in some circumstances also to legality. But it isn't clear that ASIO at its level has to comply with procedural fairness. As I said, normally it would, but there's this curious aspect that the Minister doesn't have to. So I suppose if we were to have a list of things that in our oversight interests, and I stress no further than that, might be clarified if the legislation is to be reviewed, clarifying this aspect of procedural fairness, yes or no, whichever the policy choice might be made, that would be of assistance to this office.
Thank you, Mr. Jessup. I'll go to other colleagues if they have questions. Deputy Chair.
Thanks, Chair. Thanks very much, Mr. Jessup. Can I just take you to that point that you just made in relation to whether the Act should be clarified as in relation to whether ASIO should provide the individual procedural fairness. Do you think that the way the legislation is drafted currently, that the Minister does not owe the obligation to provide procedural fairness, because one might envisage a circumstance where it's in fact very difficult to provide procedural fairness to an individual that has a TEO made against them, in circumstances where they may be in Syria or some parts of Iraq, where there's just not that opportunity for communication. And you might then say, well, should the order be made in the first instance without that? But the reality is that the TEO regime is put in place to buy the government time to undertake certain investigations as to whether certain terrorism-related offences have been committed, and B, buy the government time to put in place certain supervisory actions when the person is returned to Australia. So I'm posing the question is it possible in those circumstances for procedural fairness to be provided?
That's an interesting question. May I say that I can hear everything you said, Mr. Wallace, but I can't actually see you. I don't know whether there's a technical aspect.
You're a lucky man.
Oh, you're on the phone,
You're a lucky
are
man,
you?
Mr. Jessup. No, for some reason my video is not working, Mr. Jessup.
All right. Well, let's hope that your video hasn't been supplied by the people who are going to bring us driverless cars. So the answer to your question is whether or not procedural fairness should be given either at the ministerial or at the ASIO level under Section 10 is a policy matter, and of course the matters to which you referred are we would accept important considerations in resolving that issue. Our point is not so much that there should be procedural fairness. It's more that if there isn't to be procedural fairness, perhaps that ought to be made clear. Whether there should be or there shouldn't be is really a policy question, and no doubt the legislature will take into account the, for want of a better word, I'll say perhaps the problematic aspects of the fact that the person you're dealing with is by definition not in Australia and may be uncontactable and even in a war zone. And I think these aspects were referred to in the explanatory memorandum for the bill when it was originally introduced. So we don't seek to have any input on how the legislature should view those aspects or how they should resolve them. We recognise that is, if you like, a policy explanation for why the legislation provides that the minister doesn't have to provide procedural fairness. If it's accepted that the minister doesn't have to provide procedural fairness, it may be a rather challenging concept to work out how ASIO could provide procedural fairness, but our inspector's position is that they go to ASIO and they look at the materials and normally in a situation where ASIO makes, if I can put it at a very high level, an assessment of this kind, then procedural fairness would be something that our inspectors would look at. And in this particular context, of course, it's not clear whether they should. Now, of course, if it's decided that procedural fairness should be applied at the ASIO level, then we accept that perhaps opens up a series of questions about what the content of that obligation is in a circumstance where the person concerned is necessarily outside Australia and quite possibly of unknown location. I don't think, Mr. Wallace, I can perhaps take it any further than that. My concern is simply to draw attention to some of the oversight issues rather than to point the policy department or the legislature in either of the two directions that might be available.
Thanks very much, Mr. Jessup. Thanks, Chair.
Thank you, Deputy Chair. Thank you, Mr. Jessup. Any other questions, colleagues?
Sorry, it's Julian. I missed
Mr. Hill?
I missed about the first couple of minutes of questioning. Did we ask any questions regarding any other issue raised in the submission, the information provided to the Minister?
I'm sorry, I didn't catch that.
That's fine. That's fine. In that case, I'll review the Hansard. All good. Thanks.
Yes. Any other questions? No? Thank you. Thank you very much, Mr. Jessup, for your attendance today. I think that it may have been during the course of this hearing that you were asked, or I just was asked to provide any additional information. If that's the case, please forward it to the Secretariat by 4 p.m. Monday, the 24th of October. You will be sent a copy of this transcript of your evidence, and we'll have an opportunity to request corrections to transcription errors. Once again, thank you so much, Mr. Jessup, for appearing today. Appreciate your time. Thank you very much.
Thank you, Chair.
Chair, can I just bring something to your attention?
Yes,
Yes,
Deputy Chair.
My computer is telling me that my computer is about to do a sort of an urgent restart in 14 minutes with a software update. So I'm assuming that you're all...
The same thing happened to me as well, and I swapped computers.
So I'm about to get locked out very shortly, I think.
Well, we've got we've just finished a little bit early, so we can have a little extended lunch break. Home Affairs is on Shenya at Secretary at 1:15. Is that right? Yep.
Chair, are we excused now from the hearing room?
No, I'm just speaking to the Secretariat.
All right. Well,
Yes, Chair, the
say
next
goodbye.
witnesses are on at 1:15.
Great. All right, colleagues, we've got lunch now, a lunch break now, so I'll see you here at about 1:10.
Thank you. Thank you.
Department of Home Affairs, Border Force Australia, Federal Police and ASIO. I welcome all the representatives of all those organisations to give evidence at this public hearing today. Just for the Hansard record, would you each please state your full name and the capacity in which you appear before the committee?
Andrew Kefford, Commonwealth Counter-Terrorism Coordinator, Department of Home Affairs.
Richard Feeks, Deputy Counter-Terrorism Coordinator, Department of Home Affairs.
Steve Webber, First Assistant Secretary, Disputes and Corporate Law, Department of Home Affairs.
Penny Spees, Commander, Special Investigations Branch, Australian Border Force.
Mike Burgess, Director General Security.
Ian McCartney, Deputy Commissioner, Investigations, Australian Federal Police.
Scott Lee, Assistant Commissioner, Australian Federal Police.
Excellent. Thank you so much. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. So thank you all for attending this hearing. I think I might go to you to see if you want to make any opening statements or before we go to questions. So it might be in the order you started in or an order up to you.
Thank you, Chair. I do have a brief opening statement. And thank you for the opportunity to appear before the committee today. The Temporary Exclusion Orders Act forms part of the government's suite of legislative measures to respond to the threat posed by returning foreign fighters and Australians of counter-terrorism interest. Demonstrates a continuing commitment to keeping Australia safe by giving Australian law enforcement and security agencies the ability to manage the expected return of individuals in a controlled manner. Delaying the return of Australians of counter-terrorism interest and the temporary exclusion orders and return permit schemes provides agencies with additional time to investigate and develop a contemporary threat picture in relation to certain individuals. This additional time has been particularly crucial in the case of individuals who spent extended periods of time offshore in ungoverned spaces or have been arrested for foreign terrorism offences in other countries. In these cases, available information may be incomplete or fragmented, and agencies may require further information from foreign governments to complete assessments of the threat posed by the individual. Such information is particularly difficult to obtain where an individual has spent time in a conflict zone. To date, 8 TEOs have been made and 5 return permits issued. Australia's CT legislation framework is mature and robust. It continues to be important that agencies have the means to tackle the enduring threat. This includes ensuring that counter-terrorism legislative schemes are flexible and adaptive to respond to a complex and constantly evolving threat environment. The Act forms an important element of Australia's robust and wide-ranging counter-terrorism legislative framework, provides forewarning to those of counter-terrorism interest returning to Australia, and allows appropriate risk assessment and mitigation measures to be implemented. As international borders reopen after the COVID pandemic, Australians of CT interest have increased opportunities to return. The reopening of borders may also increase the number of Australians seeking to travel offshore. Approximately 65 Australian and former Australian men and women are currently in Syria and Iraq and have fought with or otherwise associated with violent extremist groups that remain in the region. The TEO Act plays a specific role in managing Australians of CT interest, provides a mechanism to delay a person's return to Australia and allows agencies critical time to generate a contemporary threat assessment of the risk posed by the entry of those persons to Australia, which informs the development and implementation of appropriate risk mitigation strategies, including the return permit conditions to assist agencies in onshore monitoring. The Act is reasonable, necessary and a proportionate tool that plays a valuable part in contributing to the safety of the Australian community. I'm very happy to take the committee's questions. Thank you.
Thank you very much, Mr. Kerford. I might start off. We've heard evidence in the hearings and also through the submissions.
Excuse me, Chair. Sorry to interrupt. Do you mind if myself and AFP do our opening remarks as well? Apologies.
Oh, yeah, sure. You want to do it that way? That's fine. No, go ahead, Mr. Burgess.
Thank you. Apologies for that. So ASIO's purpose is to protect Australia and Australians from threats to their security. These threats are complex, challenging and changing. Espionage and foreign interference has surpassed terrorism as Australia's principal security concern. This reflects both the growing scale and sophistication of the threats to our way of life, as well as a recent moderation in ASIO's counter-terrorism caseload. It's critical to note, however, that the threats to life will always be a priority for ASIO. The most likely terrorist attack scenario in Australia continues to be a lone actor attack without warning, using a rudimentary and readily available weapon such as a knife or a vehicle. Since 2012, around 230 Australians, or former Australians, travelled to Syria and Iraq to join religiously motivated violent extremist groups like ISIL and Al-Qaeda. Some, but not all of these individuals, are likely to maintain violent extremist ideologies, links to other extremists, and if they return to Australia, they will bring home capabilities learned in a conflict zone. Some, but not all of these individuals, may pose a latent threat to the security environment, although we assess this is unlikely to significantly change Australia's overall threat landscape in the near term. Temporary exclusion orders provide the Australian Government with an additional tool to manage Australians of counter-terrorism interests offshore and their return to Australia, including, subject to the approval by the Minister for Home Affairs, a post-entry conditions to prevent an individual from resuming terrorist activities once back on shore. Given the potential security threat represented by Australians of CT interest still offshore, the TEO remains an important tool to manage their return to Australia. Australia's counter-terrorism framework is mature and robust, and the TEO, or temporary exclusion orders, are a valuable part of this. Thank you.
Thanks, DJ. Thank you for the opportunity to appear today. Importantly, as this is the AFP's first appearance before the committee under this Parliament, I'd like to acknowledge the importance of the role of this committee plays in oversighting intelligence and security matters. The AFP is committed to being an open and transparent with the committee as possible to keep you informed on the work of our agency and our operating environment, and we look forward to briefing you further in due course. Protecting the Australian community from terrorist threats continues to be our #1 priority. The AFP echoes the comments in the opening statement from the Deputy Secretary Kerford and would like to reiterate that the TEO scheme provides the Commonwealth and law enforcement agencies with valuable time to assess and to develop strategies to manage the return of foreign terrorist fighters. The AFP continues to work collaboratively with its partners to assess and manage foreign fighters on a case-by-case basis and consider the most appropriate legislative mechanism and develop risk mitigation strategies. As set out in our submission to this inquiry, the AFP has put forward some minor suggestions for consideration, which can improve the operation utility of the TEO scheme, and I would be more than happy to elaborate on these during the hearing today. Thank you again for the opportunity to appear today, and we welcome your questions. Thank you, Chair.
Thank you. Are there any other opening statements? No? Ms. Penelope Spees? Yep.
No opening statement. Thank you, Chair.
Sorry, Chair, just ask the witnesses to try not to shuffle the papers so much because it's almost
the
impossible
microphone's
to hear.
catching it. Yeah, thank you, Mr. Hill. It's a very, very good microphone, actually, so we're picking up all of your movements. Just be aware of that. Can I just, before we kick off, we've only got 45 minutes and we have 4 separate organisations in that short, relatively short time frame. And if members could keep their, to their main couple of questions and leave some supplementary questions that they may have until the end if there is time at the end, so that we can cycle throughout the committee. I might just kick off, if I may, and thank you all for your opening statement and for being with us here today. We've heard quite a bit of evidence from other stakeholders, both today and through their submissions, and they've submitted that there's been insufficient evidence on the public record regarding the operationalisation of the TO regime. Could you, particularly AFP and ASIO, advise at how this regime is used to manage the national security risk? You touched on it a bit in your opening statements. And can the department advise what that process, what's involved in that process, including this issue around ministerial consideration, which we've heard quite a bit about today, and whether the minister is given, an assessment that's made by ASIO under 10.2b or not, as the case may be.
Thank you, Chair. I might go first from an AFP perspective. I think from a real practical perspective, the TEO scheme is extremely beneficial. It provides us valuable time, if required, to gather further information and evidence, and also to control the means of those that would return into Australia. So there has been a number of instances where that's provided benefit to us in terms of further time to gather further information and evidence, and information not just for ourselves, Stuart, but also for our intelligence partners in terms of having a better informed risk assessment of that person returns to Australia. So there's been individual cases where that's occurred. There's been individual cases where we've been concerned if that person does return to Australia, would create issues for us. But as we've worked through the information, that the risk level in relation to that person has reduced. So it's been a valuable tool in terms of the work that we've done.
Thank you. Mr. Burgess?
Yeah, likewise. I'll be brief. A valuable tool. I'm with my colleague from the AFP. The timing is absolutely of value. Time has a quality of its own. And where we have individuals who have left this country and travelled to an area and joined or participated with groups such as ISIL or Al-Qaeda, it's critically important that we collectively have time when these individuals wish to return to this country. So from that point of view, from ASIO's perspective, that time is a very useful capability the tool offers. There are broader utility that provides, but I'll let other colleagues jump in accordingly.
And just, Mr. Burgess, that is to build up, obviously, further evidence or intelligence that might provide further evidence around a charge and so on. I understand that. That other part of my question was in relation to 10.2b, and at what point, for example, the minister receives that assessment that's made by ASIO, or could you describe the process for coordinating advice for the minister's consideration in those scenarios?
Chair, I might outline that process briefly for the committee. In short, the work is the coordination work is undertaken through the CT Coordination Centre in Home Affairs, and so there are ongoing structures as part of the CT frameworks that enable the police and security agencies to provide input, share knowledge on when we think people might be seeking to move, and based on that, there is a collective process whereby that evidence is collected, including assessments to which you've referred. That is put together again in a normal process into a submission for the Minister for Home Affairs. That includes the material, intelligence, and other factual material in our possession, as well as legal advice on the application of that material to the criteria that are set out in the Act. And at the point that's been prepared as coordinated advice and comprehensive advice, that structure through that structure, it's put in front of the Minister for Home Affairs by me as the CT coordinator.
Thank you. Just given the nature of the power, which is effectively a barrier to bringing someone in, and you've described it as it gives you that opportunity to have time, frankly. But is the waiting around the decision making, or at least the advice to the minister, weighted towards the national security risk of that particular individual re-entering the country and what risk they pose in there, or is it weighted towards the evidence and assessment around and the build-up, I guess, of intelligence and other assessments that may lead to a charging of that individual under a particular law?
I think all of those considerations are relevant, Chair. The way I'd describe it, though, is the process takes place in the context of recognising ultimately the right of a citizen to return, and that's evidence in the way the Act functions in terms of the return permits component as well. And as is set out in the Act, the safety of the Australian community is the paramount consideration. The benefit of time, without repeating the evidence from my colleagues, it allows for preparations to be put in place. There also is an element of engagement with the states and territories in terms of the ongoing security surrounding the individuals once they're here. So it allows time, but at the end of the day, the Act exists to protect the safety of the Australian community while recognising ultimately the right of citizens to return to Australia.
And finally, and I do have further questions, but I do want to cut myself off to give time to colleagues. But finally, just excuse my ignorance, of the 8 TOs that have been put in place, have they all led to charges being laid? Those individuals?
No, Chair. Of the 8, there are 5 return permits have been issued. 4 of those have been actually taken up. And 2 of those have been subject to post-entry conditions. But that's in terms of managing the returns. On the charging, I'll defer to the Deputy Commissioner.
Yes, Chair. One subsequently been charged when a person returned to Australia. But I'd probably going back to your earlier question, if before they return to Australia, if there's sufficient evidence to charge and prosecute, we look at these matters on a case-by-case basis. We'd probably allow that person to come back into Australia without a TEO, and we've done that on a number of occasions.
In order to charge them after they've come back, is that what you're saying?
Mm-hmm.
Yeah. Okay. I might, thank you very much. I might move to colleagues now, to the Deputy Chair, just so we have enough time for all colleagues to ask questions. Over to you, Deputy Chair.
Thanks, Chair, and I'll take that warning as being directed at me. So when I've too much,
Not at all.
Just cut me off at the knees like the Black Knight.
I cut myself off, Deputy Chair. The floor is yours.
All right, thanks very much, Chair. Thank you for your appearance today. I can't see you all, and I missed the first part, so I'm not sure whether we've got any ladies in the hearing room, but I can certainly see gentlemen. So thank you for your appearance. One of the concerns that was raised by the Law Council is in relation to their words, and I think they've got a relatively good argument about the opaqueness of Section 10.2b in relation to the assessments that are conducted by ASIO. In relation to, so 10.2b talks about the person that's been assessed by the Australian Security Organisation as to be a risk to security. That the Law Council is concerned that that's a very opaque provision. That there's no legislative guidance on what the assessment should be conducted by. Mr. Burgess, keen to get, or any of your colleagues in the hearing room, about the
Sorry, I missed the last part of your question. Your audio's been going out at the end there.
I'm sorry. My question is around 10.2b. The concerns around the opaqueness of the assessment procedure in 10.2b.
Certainly. So in terms of our role is when we provide the Minister with our intelligence assessment of whether someone is directly or indirectly a risk to security, as in case of politically motivated violence, that is classified information that we provide to the Minister. So I acknowledge in terms of that level, others can see that as opaque because it's not available to anyone else because it's a classified intelligence assessment.
So the Inspector General of Intelligence and Security, I think, also raised that as an issue. Do you have any concerns that it's too opaque?
As a matter of principle, I think it's important in this country and how we operate that there is, the rights of the individual and procedural fairness do come into mind. So in that acknowledgement, I would suggest that actually it's not as clear as other things that we do, and specifically our security assessments under the Act, but there are operational reasons, in fact, that my colleagues from Home Affairs might want to talk about in terms of the policy position on why procedural fairness in this case, as in why we wouldn't tip an individual that they may be subject to a temporary exclusion order ahead of them being given a temporary exclusion order. And I suggest that's probably why we've ended up the way we have ended up.
Well, that's probably a good segue to hand over to Home Affairs on that point, please.
Thank you, Deputy Chair. And the Director General's outlined the argument. The concern that we have, noting the overarching purpose of this legislation that is inherent in the way the Act is drafted at the moment, is beyond the practicalities of providing the sort of access to information that might happen were proceedings to be held in Australia. There is a concern that were individuals of concern to be engaged ahead of orders being made, there's actually nothing to stop them seeking to expedite their travel and to come before that process has been concluded. And so while there are mechanisms post-decision and indeed post-arrival, as well as the application to which I referred earlier, where if the individual in question requests a return permit, one must be granted. The argument advanced when the legislation was introduced and the decision taken at the time was the risk in pre-warning individuals of security concern or of terrorism concern that they were being considered for a TEO might actually provoke the behaviour that the Act is intended to manage, which is return to Australia without conditions and without necessarily proper notice for the police and security agencies.
Okay, anyone else there? All right, I'll take that as a no. One of the other comments that's been made by the Law Council is that, look, these TEOs aren't really required because control orders would be more appropriately made. I'm keen to get your thoughts on those comments.
Well, I think control orders deal with a person when they return to Australia. The TEOs, as we've said, and I think a number have said, Co-Chair, that they provide us time to delay that person's return into Australia to gather further evidence and information. The issue of ICOs or control orders, these tools that we utilise are not mutually exclusive. We can complement the TEO with an ICO if we deem that, or the courts deem that is an appropriate course of action.
One of the if I could, sorry, Deputy Chair, sorry, it's the Chair here. Sorry, if I could just ask a supplemental to your question, Deputy Chair, because the Law Council also, on this question of time that you've just answered about the giving yourself time and space to gather further evidence and gather further intelligence in respect to that particular individual, one of the arguments they made was that that would be better done with a person in country because you'd be able to interrogate them directly here under a control order. What's the answer to that particular point?
Chair, I think it's Scott Lee from the AFP. I think from our perspective, I think they're complementary. So there is the time that is allowed to us through the application of the TEO that provides us with sufficient time to attempt to obtain evidence and obtain intelligence in terms of better understanding the threat and risk of an individual and the reception planning that we would undertake prior to that person returning. Those matters that you raised, we obviously still do undertake when they're back on shore, but they're complementary, and certainly from our perspective, I think as both the DG and the Deputy said, that time that is established or allowed to us is valuable time before they're back on shore, and we're attempting to manage the risk in community. The other point I would make, just in terms of the control order issue, is the TEOs do provide a scalable piece of legislation where we can still put some control around the individual in terms of the application of conditions, which are primarily notification conditions where we cannot meet the threshold for a control order, given return permit conditions that do not have the same level of intrusiveness as a control order, but they're still valuable to us in terms of attempting to mitigate the risk of an individual where we can.
Thank you. Back to you, Deputy Chair.
Thanks, Chair. Home Affairs, I'm assuming you had carriage of the preparation of the wording of the bill, is that right?
Yes.
I'm just wondering if you can help me out. I'm just curious that, and perhaps I've missed it, but there's only 2 references in the Act about the paramountcy of the protection of the community, and that's both in relation to the making of an order under 10.3 for children between 14 and 17, and then the same in relation to a return permit. Is there somewhere else in the bill that, in the Act, that talks about that that isn't just for children, but it's actually perhaps self-evidently also in relation to orders made against adults?
Deputy Chair, I'll make 2 observations. One is that it's mentioned in the long title of the Act. I'd have to, and happy to take on notice if you like, to go back to the explanatory material at the time that would set it out further. You're right, the specific references to paramountcy do come into discussions about the making of orders in relation to children over between 14 and 17. But I think if you look at this Act in the context of the overarching or the entire counter-terrorism legislative framework, then the purpose of these arrangements is clear, as are the intersections with the other legislation that the Assistant Commissioner was just referring to.
All right, well, you'll come back to us on that. Would you agree that if the committee ultimately recommended to government that the Act be retained with whatever recommendations there might be about some amendments, that the 3-year review should be a rolling review?
Well, I think, Deputy Chair, that would be ultimately a matter for the government, but there's a number of pieces of legislation in the overarching framework that have regular reviews, and I think the ongoing scrutiny provided by this committee and other processes is valuable.
Because the review that's currently we're undertaking is only a one-off review, as I understand the legislation.
I'd have to check that, Deputy Chair. Is that right, Steve?
Steve Webber here from Home Affairs Legal. It is a one-off, but it is also worth noting that the Intelligence Services Act gives this committee power to monitor and review the exercise of TEOs just generally. Whether the government wishes or the committee wishes to make that regular is another matter.
All right. Now, I'm going to ask a question that may sail close to the forbidden question of asking a public servants about policy. So if I sail too close to the wind, then you'll no doubt pick me up. But one of the other issues that's been raised by the Law Council and the Human Rights Commission is that the exercise of the discretion to order a temporary exclusion order is one that should be a judicial discretion rather than one made by the executive. Are you able to talk to the committee, because this ultimately is going to need to be considered by us, as to how it was originally landed on an executive position as opposed to a judicial discretion, and the benefits and otherwise of that decision?
I might perhaps start with that question, Deputy Chair. Steve Webber from Home Affairs Legal. It's important to contextualise the TEOs in that sort of cascading regime where you have perhaps at the top prosecutions, then control orders, and then TEOs, each with quite different consequences. And the TEO regime is a regime where you ultimately have the consequence of conditions attached to people's presence in Australia. And at that level, it was seen at the time the TEO regime was made that a ministerial authorisation was the appropriate authorisation. And it is also worth noting that it isn't necessarily the case that authorisation by a judicial officer for a decision like this is legally sound either. So you have to always tread.
And we're not so much talking about whether the ultimate decision is legally sound, but which is the better way of going about making these decisions, given that we're involving very significant constraints on Australians' liberty. As I understand it, the TEO legislation was modelled on the UK version, and the UK version has the decision maker as a judicial officer. So, why was it considered that the UK model was in some way deficient, that we needed to give that power to a Home, or in this case, a Home Affairs Minister?
Well, the UK model has quite a different underlying underlying criteria, which requires, I think, knowledge or satisfaction about prior behaviour of an individual, and the regime here requires satisfaction of future risk to an individual. So the decision-making process by the decision maker is a different process, and that future-looking operation of the Act means that the sort of information that's available to the decision maker is information that can be presented in a different way.
I'm not sure what that means, but is there some concern about classified information being made available to judicial officers?
Oh no, not at all.
Right. Well, do you want to?
I'm only saying that in the context of those regimes, with the TEO regime being a regime with the consequence of conditions on arrival, and a regime where people can always ask for a return permit to be granted, and the need to do these things expeditiously in our operating context, that was the model that was chosen.
I can certainly.
Sorry.
I butted in then.
No,
I'm not sure.
apologies.
I can't see who's trying to speak, but
Apologies, Deputy Chair. It's Mike Burgess, Director General Security. Apologies for cutting you off. I think the delay meant I cut you off, so my apologies. Obviously, it's a matter for government and the Parliament in terms of who and how such a decision would be made. From my perspective, just to agree with and add to my colleague from Home Affairs comments, yes, I would have concerns about protection of classified information. So whether it's passed to a minister or a judiciary, a judge or someone of the court, no issue with that. I would only ask that if the committee is considering that, actually we're very clear on the grounds on which that information must be protected. Because from my agency's perspective, and I know it would be from the case of the Australian Federal Police and others, protecting sources and methods are absolutely critical. So whilst someone else can make the decision and have the full information available to them, I would ask that we ensure there are appropriate methods and mechanisms in place to protect that classified information.
And assumedly, Mr. Burgess, there would be other regimes that those protective measures that you're talking about could be utilised as a blueprint for those sorts of protections.
Correct, that's true. This happens in other cases today. and this is me communicating to the government through a committee, but I'll chance my arm. Whilst I remain concerned that we have lost sight of the reasons why we need to protect classified sources and methods and classified information, and that's why I raise it as a matter of concern for me, continuing to make sure that whatever decisions are made, any legislation that's updated, and actually it's very clear the means by which and how that information is protected, so the process can be run in the way the Parliament needs it to be run, but also protects the information that the Director General of Security would require to be protected to operate effectively going forward.
So can I assume, Mr. Burgess, and I'm not trying to put words in your mouth, but I'm making the assumption that ASIO is less concerned about who makes the decision, but very much concerned about the protection of the information which goes to the making of that decision.
Correct. It's not for me to determine what the decision on how it's done. That's a matter for others, a matter for the government itself.
Okay, thank you. Deputy Chair, I'll hand back to you.
Thank you, Deputy Chair. I'll give the call to Mr. Hill.
Thanks, Chair. I'll just follow up on sort of those two matters, actually, which we've covered, just to tease it out a little more. Would ASIO or Home Affairs have any concerns if there was a clearer requirement that the ASIO security assessment was provided to the Minister or decision maker, whoever that was, as part of the decision making?
Well, at the moment, actually, my security assessment is provided to the Minister.
Right. So it's just that there's not a specific statutory requirement to do so.
Mr. Hill, it forms part of that advice to which I referred before, that's coordinated through the CT Centre.
Okay, that's fine. I was just a little unclear, or maybe I missed it, as to whether you were distilling the advice and drawing on other sources, as I think you said, or whether the raw advice is sitting on the back of the file. So there'd be no practical concern in making that a requirement, which is a small but persistent concern of a range of the external submitters.
That would be consistent with existing practice, Mr. Hill. In as much as we write a submission for consideration by the Minister for Home Affairs, we also provide the assessment in full along with the legal advice.
It's Steve Leder here.
Sure. Okay. No, that's terrific. And you understand the point that I'm making from a public administration point of view. You know, the Auditor General, just other people periodically raise concerns that a coordinating agency has sort of distilled and morphed a bunch of advice, and the decision maker doesn't have the raw information in front of them. So that would be a tidy up requirement, which you wouldn't be concerned by. Just on then the last point, to look at it also from a different point of view, there have been concerns raised by submitters regarding the constitutionality of the bill, and indeed that was raised, I think, in the initial process some years ago. Has further consideration, or has the department had cause after the citizenship case in Alexander to revisit this question in relation to TEOs?
Well, I think I might start, Mr. Hill, and I'll defer to Mr. Weber. And without going into what the Commonwealth's legal advice is, we at the time the original bill was passed, and subsequently the view is that the sorts of controls here on a citizen's right to return are appropriately measured and proportionate to the risks that are being managed. It's not an absolute prohibition on return, and so our view remains that the basis of the TEO regime is sound. Clearly, it has not been tested in the court, but that was the advice and the approach adopted at the time, and we've not had cause to disturb that view.
It's not quite what I asked, but
including in light of the case to which you made specific reference.
Right. Could you be aware of the Law Council's views where they drew attention from a constitutional point of view to two concerns, and they both go to the points Mr. Wallace was making earlier regarding how the decision is made. And I think it's been the position of the government and the opposition that there's an acceptance and support for the need for such a regime, notwithstanding the fact a lot of submitters take a different view. But the issue we're trying to grapple with is how the decision is made, and whether changes to that may reduce the constitutionality risks and shore up the regime itself, which, as you say, is pretty important.
Indeed. I'm sorry, I'm not sure I caught the question in what you've just
Sorry,
said.
you're aware of the two concerns of the Law Council, that they said there's a reasonable or responsible argument that this is an extrajudicial power and that breaches the Constitution, and similarly with the review powers, that they're also judicial powers. And they pointed to Section 30 in the Act, which appears to acknowledge that there's at least an arguable case.
Steve Webber here from Home Affairs Legal. The department's position is that the Act remains constitutionally safe, as Mr Kefford just outlined, and I think I add only to that what is obvious, which is and because your question arises out of the Alexander case, that's a case about the loss of citizenship, which is a permanent state of affairs should it happen, and factually this is quite a different circumstance where you are looking at the suspension of the right to return only until somebody asks for permission to return, and then the imposition of conditions on return, which we know from the operation of the control order provisions is something that is constitutionally sound.
Yeah, okay, I get the argument. I'm not sure I'd want to run it, but you referred earlier, I think, in response to Mr Wallace's questions about why you may prefer a minister to make this decision as opposed to something that may lower the constitutional risk, according to the Law Council, whatever form that took. And I think you used the words expeditious. I think in the previous government's response, you also pointed out that it would be cheaper not to have those pesky lawyers involved. Pesky lawyers were my words, but I think there was a cost issue. Are there any other reasons apart from speed and the fact it's cheaper that you could point to why a different regime would be problematic?
Steve Webber again. It really is about the design of the scheme here as it operates alongside with other schemes, namely the control order scheme and the criminal laws. So we would only say as a department it's not as simple as expedition, but certainly with the regime we have under the TEO regime, which is a regime that ultimately results perhaps in, does ultimately result in conditions that are far fewer and less onerous than the control order conditions. Your first stop where you need to do something in between somebody arriving and the control order is to be able to put in place some kind of management with speed.
Yeah, I understand that, and presumably you had someone listening at home at least to our discussion this morning. It was pretty clearly acknowledged by everyone in the questioning and the responses that if the decision maker was someone other than the minister, then the minister would, as happens in the UK, of course require the power to make a quick decision. I don't think anyone would disagree with that. So I suppose I'm just trying to get on the record. Are there any other reasons apart from expeditiousness, the fact it's cheaper, and some sense of alignment with other regimes, which you haven't really explained? I don't understand why you would have a concern if the decision maker was someone other than the minister.
Mr Hill, I'll just explain the point or add to the point Mr Webber was making about the hierarchy. That for more significant controls, there are more complicated or more complex processes, if I might describe them that way. What we're suggesting here is that, given the operation of the Act as a whole, the fact that even if a exclusion order is made, a return permit must be issued, and the consequences are not as stringent for the individuals as exist under other parts of the criminal code in terms of control orders and so on, that there is a balance to be struck in terms of the level of that decision making and the overall complexity of the process.
Yeah, well, look, okay, that's fine. If you've got any additional words, the concern for me in exploring this, and I've informed a view, and the committee has informed a view, I'm sure, because we'll talk about it and reflect on it, The concern for me is, given the former government stuffed up the citizenship legislation, and that puts even more pressure on this as a regime that needs to be effective and work. And those concerns about the constitutionality that the Law Council have outlined don't seem spurious. I admire your confidence, but I'm at least trying to understand what options we may have to reduce the constitutionality risk and shore up the regime on the basis or the assumption that everyone agrees it's important to retain. And sure, there's things we can do to improve it and so on. So that's the perspective that I'm coming from.
And I accept that, Mr. Hill, and we're not saying that the sort of process that you're describing is not one that's open to ultimately the government and the parliament to institute, but what you've asked us is to explain where we are now, and that's what we've done.
Okay. No, thank you. If you just had a short note, like any extra words to help us flesh out that point that you're making about the hierarchy of things, that would be helpful, because I'm new to the committee and I still haven't got my head around all of the detail of those other complementary regimes.
Happy to take that on notice, Mr. Hill.
Okay. Thanks,
Thank you.
Chair.
Thank you, Mr. Hill. Ms. Andrews or Senator Patterson, do you have any questions? No. Senator Smith or Senator Ciccone?
Don't mind, have been covered, Chair. Thanks.
Chair, I just wanted a clarifying remark following Mr. Hill's line of questions to the department, just so that I'm clear. So is the department saying that, or does the department have a view whether the regime to be able to issue these TOs would work better or not better if the minister was not the person who had to issue the TOs?
Well, Senator, you're asking for our advice in that question. What I've said is that certainly the option to have the decision made by a judicial officer of some capacity is certainly one that's open to the government and the parliament to ultimately institute, at which point the department would implement it. But we're not. That's not something. Not an issue on which we've given particular advice.
Because you haven't been asked to provide that advice. You don't have a particular view. Like, I mean, we're just trying to explore how we can make the functionality of this better. You not have a particular view, or the department has a view whether it should be the minister or a judicial officer that issues these TOs.
Well, again, Senator, we need to implement the scheme as it is in front of us in the Act, and that's what we do. The arrangements that we have in place in the department's view, as Mr. Webb has outlined and as I've highlighted, is that the mechanism sits within the overall framework and sits comfortably. That's a different answer to are there alternatives available? Of course there are.
And do you have a particular view on those alternatives, or want to share with us?
Well, again, Senator, you're asking me to either speculate or provide policy advice or both. There are benefits to the efficient operation of the scheme in the way that it's drafted. There are, and Mr. Hill asked about our view of the legal issues. There are also other schemes with which we're familiar in other countries that operate in different contexts in different ways. And certainly, as I've said, it is an option for this process to be done through a judicial officer, subject to the comments that the Director General made. But that's not a matter on which we have provided advice.
All right, I'll leave it there, Chair, for now. Thank you.
Thank you, Senator. Thank you, Mr. Curford. Well, we might go to round two, so I might come back to myself now because I had a couple of additional questions. What obligations does the department have to notify a person? You might have touched on this earlier, and excuse me if I missed it, but to notify a person that they are subject to a TEO or control order, and operationally, how would that occur, given their location?
Well, I might start with the practice, and then I'll ask Mr. Webber to add to the clarity of where the obligations lie. In some respects, it would depend on the circumstances of the individual. So there have been cases, for example, where, as the Act provides, the application for a return permit or the process is transacted through representatives in Australia. In other cases, we dispatch information, notices, letters and so on to the last known address of the individuals, recognising that some of these people may have been where they've been for some time.
And Chair, I might just add that the Act provides that the Minister must take such steps as are reasonable and practicable to notify somebody that a TEO has been made.
And do these persons have access to the ones that are subject to a TEO or a controller? Do they have access to legal assistance or case management through a third party?
Not through the TEO Act. That Act doesn't provide for that kind of assistance, no.
And are they able to source that assistance through another pathway?
That would be something, each individual case that would be different, would be just dependent on an individual's circumstances.
There was I think it was in the 2021 IGES annual report, it advised inspections during the reporting period identified a need for ASIO to capture its role in the temporary exclusion order process in formal written procedures. What steps, I think this is for Mr. Burgess, what steps, Mr. Burgess, has ASIO taken to action this particular finding, and have other agencies also considered if they need to better reflect their role?
From our point of view, Chair, we have updated our intelligence policy manual that includes our steps in this process.
Thank you. And the other organisations, agencies, I'd say?
Well, I think our information in relation to issues such as this are fed into ASIO's assessment, so that will be included through that process, Chair.
Also, just a question for you, Mr. Burgess. This is probably another way of asking a question that's been asked already in a couple of ways, but are there any scenarios or are there any prohibitions in place preventing a copy of the assessment from being provided to the Minister to support decision making? Or this might be to you, Mr. Kerfoot. Are there any sort of instances where you wouldn't provide the assessment?
There's not, from my point of view, so it's Mike Burgess, Director General Security. From my point of view, there's nothing that stops me from providing the Minister the full details of our assessment. It's not a formal security assessment as per the ASIO Act. It's our intelligence assessment based on the information we have at hand, and there's nothing that prohibits me or my organisation from providing that to the Minister for Home Affairs.
Right, thank you. Mr. Kerfoot?
And all I'd say, Chair, is that it's our practice to do so.
Great. Question for the AFP. Could you comment on the type of post-entry conditions that might be imposed under a return permit, and how are these conditions selected? What processes does the AFP have to monitor and review these as well?
Yeah, sure. It is very much on a case-by-case basis, but I might just pass to Assistant Commissioner Lee to outline them.
Yeah, thanks, Chair. Firstly, in terms of the conditions that may be considered, we coordinate that through the whole of government processes that Mr. Kerfoot touched on before, in terms of the information that we may provide to assist the consideration around the issuance of a TEO, and then we coordinate with the centre and other agencies around what conditions may be reasonable and able to be adapted and proportionate to the individual. In terms of the conditions themselves, I can say that have been applied in terms of some of the return permits that have been issued. They go to such things as to the principal place of residence and notifying within 24 hours of any change of residence. Within 24 hours, entry to or an intention to enter a state or territory that is not the state or territory in which the principal place of residence is located. Within 24 hours, departure from or an intention to depart Australia. Notifying of any access or use of telecommunication services, and also notification within 24 hours of submitting an application for an Australian travel document. So they also go on to talk about notifications for employment in Australia. So they are the types of conditions that have been obtained already in relation to a number of individuals. And going to what Deputy Commissioner McCartney touched on before, there's been one individual who's been charged in relation to breaching the conditions of a return permit, and that was in relation to an attempt to depart Australia without notification. That individual was also on bail for state offences in one of the jurisdictions, but that person's currently before the court in terms of those breaches of the return permit.
Thanks. And just in extending on to that those post-entry conditions, how do you then go about providing the operational information, the necessary operational information, I guess, on how you manage the whatever risks there are that you've assessed, national security risks and other risks, and how do you do that in partnership with states and territories and their law enforcement agencies? Is there a notification period, a planning period with your colleagues at state and territory level that goes that works into this return framework, I guess?
Certainly where we've got an individual that has returned who is of concern and is subject to return permit conditions, obviously we've got extremely mature national frameworks through the joint counter-terrorism teams and our joint counter-terrorism team framework that involves ourselves, ASIO and our state and territory police colleagues, both from an investigative and intelligence perspective. So that's the way we coordinate any sharing of information, any indication that might come to light that provides us with a level of concern that there could be an escalation of risk or otherwise. So we do that. We do it very much through those mechanisms, Chair, and that obviously includes Home Affairs and the Australian Border Force. And then I suppose I'll probably be a little bit cautious here, Chair, if you don't mind, because some of the issues around how we might go around that obviously go to issues of sort of operational methodology and some of the monitoring or some of the surveillance coverage that we may put in place, if you like. Yeah.
Yep, no, that makes sense. I guess the other angle of this from the sort of minister's perspective, I guess, would be when you are making, I think this might be to ASIO, Mr. Burgess, when you are making an assessment regarding the return of a person to Australia, what goes into that assessment when you make the recommendation to the minister?
Well, we'd stay out of the whether they return or not. We focus on whether they represent a risk to security, either directly or indirectly, in the context of politically motivated violence. So that's the extent of our input at that stage.
So it's a threshold kind of thing where it's like, if it's low enough, that's for the minister to then determine that that person may be able to be returned. Is that right?
Well, that's entirely a matter for the minister. Our advice is our assessment, our intelligence assessment says whether we have assessed that individual is directly or indirectly a threat, a risk to security in the context of security being politically motivated violence.
Yep. Have you, all of you as agencies in the department, the relevant agencies in the department, considered if you think there are any additional conditions that may be required to manage those national security risks, further conditions that are not, maybe haven't been in place under the current framework?
I think my initial answer to that, Chair, would be you'd need to kind of ask that question in the context of the other parts of the CT framework that we've described. So in terms of does the Act as it's framed provide sufficient controls to manage the return, then I think our assessment would be, noting that we've used it eight times, is that there are sufficient controls there, recognising, as the Assistant Commissioner I think said earlier, there's nothing to prevent an application being made for control orders once the individuals are here. So it really is part of the continuum and a relatively narrow slice of that, if I might describe it that way.
Yep. Thank you. Look, I've gone through all the additional questions I wanted to ask. I might turn now to colleagues. Ms. Andrews.
Sorry, thank you very much. Now, the audio has been a little bit scratchy, but I don't believe this issue in particular has been raised, and it goes to a proposal, I believe it was from the Law Council, that in fact one of the options that should be considered is that there should be an interim TEO, so that there may be a requirement or an opportunity for the Minister of the day to make a temporary or an interim order, and then that would then be reviewed at another time. And the proposal was for that interim order to be valid for a period of 10 to 14 days. Now, I'm interested in some comments from all of the agencies and the department represented there today on their views on that, particularly in light of comments that they have made about the additional time that's required as part of a TEO. So perhaps maybe start with Mr. Burgess.
Thank you. My initial reaction to that is, if I understood what they were saying in terms of an interim temporary exclusion order, or time-limited temporary exclusion order, it'd be better than nothing. But if it's 2 weeks, that may not be enough time, is my initial reaction to that. I'd have to ponder that. I'm happy to take that question on notice.
I think we're going to parrot out the Director General of ASIO. I think with similar concerns about that time period, noting we're dealing with people overseas, and we're dealing with people overseas in countries where the access to information, let alone access to evidence, is problematic.
And Home Affairs?
Yeah, I'd certainly echo those concerns, Ms. Andrews. The other thing I'd point out is that there's, as you would be aware, there are processes for requests to change conditions. So there's the Act already provides for mechanisms for individuals once they become engaged with, aware of the issues and the restrictions, to request changes. There's opportunity for Minister to vary either the conditions or to indeed revoke the order if the circumstances change. So I think something of 14 days in this sort of context, I'm not sure would be long enough to do anything meaningful, would be my initial reaction.
Okay. Could I ask if anyone would like to provide some further information to us in writing on that particular point? It would be appreciated.
Happy to.
Okay. Also in relation to persons of 14 to 17 years of age, and again, that was raised in some discussions today. So 10.3.2 is the relevant provisions of the Act, and paragraph 4 as well. Are there any comments that you would like to make in relation to persons who are 14 to 17 years of age and the requirements that the Minister must take into account in making any such order?
Well, I might start, Ms. Andrews. First of all, just to note that these provisions have not been used. So there have been no consideration of children of that age. The way in which those provisions would play out, though, are essentially consistent with the relevant international treaty obligations, which is to, and this was one of the areas coming back to the Deputy Chair's question before, where community safety is paramount, but then the best interests of the child are the primary consideration. So that sets up a decision-making process that specifically considers matters that are relevant to the application of this sort of order to a person of that age, and in that sense it not directly but certainly mirrors arrangements that are in place under the Migration Act and other things to give primacy to the rights of children when they're being considered for these sorts of decisions.
Mm-hmm. Okay, thank you. And I have one more question, Chair, if that's okay. Yep. In relation to, again, the assessments that are done by ASIO, and this has been canvassed quite broadly before, but one of the comments that was made to us is that under the provisions of this Act, the ASIO assessment is and cannot be reviewed by any individual, any any other organisation or body. Do you have any comments in relation to that, Mike Burgess, particularly in view of the possibility that consideration may or may not be given to these orders being put in place by someone other than the minister?
Again, I would go back to the intelligence assessment that we make. That information is fully available to the minister. Everything that my organisation does is subject to oversight, including from the Inspector General of Intelligence and Security. So beyond that, of course, that information isn't available to the individual subject to a temporary exclusion order. So I acknowledge that point, but close with the reason for that is our need to protect our classified sources and methods when we come up on our intelligence assessments, or as we do our business more generally.
Any views, though, on the specific point that was made, which is that assessment is not subject to any sort of review and cannot be reviewed? So my understanding of the point that was being made is that once ASIO makes that assessment and it is provided to the minister, as has been practice, there is actually no external review of the assessment of ASIO under the terms of this Act.
So yes, I agree with that. ASIO doesn't have a view that that's a requirement, so that's not something that's put in there by ASIO, unless my colleagues want to tell me otherwise. It's not certainly something. I wasn't in ASIO when the TEO Act was being worked through, but it's not something I'm asked for. Everything else we do, it does subject to appeal mechanisms, and back to my original point of where that happens, that information is appropriately protected under law. Whether or not that wants to be introduced here, that's a matter for government and this committee, and I don't have a view on that. I'm certainly not asking for that to continue, if that was your question.
I think the point that was being made this morning, and Andrew Bowles, please feel free to jump in on this point as well too, if you wish. I think the point was being made that because there could be no review of ASIO's assessment, that was in fact a poor thing.
It was the argument was that the lack of oversight of ASIO's assessment meant that there was a lack of procedural fairness to the individual.
So I would disagree with anyone that says there's a lack of oversight in ASIO in general and everything, including this particular issue. We have a Royal Commission standing on top of us 24 hours a day, 7 days a week. That's fairly substantial oversight. I take the point, though, in the case of this one of procedural fairness, I'm not asking for anything there other than that's appropriate as a matter of principle. The procedural fairness is in play in everything that happens in this country. I would only ask that if that happens, that actually the appropriate mechanisms are there to protect the information that we need to, so ASIO can continue to be as effective as it is.
It's Steve Weber here from Home Affairs. I wonder if, Chair, I might just add one thing, which is to say, that when the minister makes the TEO, the minister has a discretion and has to make a decision. It's not the case that because there is an ASIO assessment in place, the minister can make a TEO. The fact that an assessment exists supports a decision that a minister must make, and that decision is subject to judicial review. It's true that there isn't merits review of ASIO's assessment, but the process conducted by the minister is subject to judicial review at least, and that must take into account the information provided to the minister when the minister forms the opinion that that a TEO should be made.
But Mr. Webber,
just on that, sorry, Deputy Chair, to cut in because it's just on that particular point. Just on that, I asked earlier how many TEOs had been issued to date. Of those TEOs issued to date, how many have been given under Section 10.2A and how many under 10.2B?
Well, we might have to take that detail on notice for the committee, Chair.
Thank you. If you could, that would be good. Deputy Chair, you were about to ask a question.
Yeah, I was just going to say that the right of judicial review is only in respect to it's not a merit-based judicial review. It's only in relation to errors of law. That's correct, isn't it?
Steve Webber here. That is correct.
So it's a very confined corridor of what the court can determine as to whether that decision was made appropriately.
It is a review.
Chair, can I jump in, Chair, and just ask, in Home Affairs submissions, page 10, you talk about the Independent National Security Legislation Monitor having an oversight role of the legislation. Has the monitor done a review of the Act?
Not at this stage, Deputy Chair.
Can I just flag to colleagues and the Secretariat, I think it would be appropriate for us to get the monitor in and have a chat to us about the legislation.
Thank you, Deputy Chair. We can discuss that with the Secretariat.
I still have more questions, Chair.
You have another question, Deputy Chair. Go ahead.
This question you may not be able or willing to answer in this public forum, so I'll preface it with that caveat. But the women and children which are currently in Syria, are they going to be, or are they already subject to these temporary exclusion orders?
Deputy Chair, if you might suggest that I think we have a private briefing with the committee on that matter next week, and I'd rather not answer questions about individuals in a public hearing, please.
Yep. No, that's quite all right.
Just on that, Deputy Chair, thank you for Mr. Kerford for highlighting that. We are looking at having a briefing or requesting a briefing in a more classified, secure setting next week when we're all in Canberra. So I think our questions on that can be answered then, Deputy Chair.
Yep, sure. Now, I do have another question, and this goes to the AFP. The AFP at paragraph 42 of their submissions talk about the concept of double jeopardy. And I'm just wondering if you're able to give the committee some steering on whether the rules around double jeopardy would in fact actually apply if a person was convicted of a terrorism offence in the country where the offence was alleged to have taken place, and then whether when they return to Australia, whether they could be prosecuted again for the same offence.
Well, I think Deputy Chair, it's very much a live issue, and we've had some examples of that. But ultimately, it's a decision for the Director of Public Prosecutions to look at the charge and prosecution that occurred in the foreign country and apply that to what that person could be charged with within Australia and the circumstances of the case. So, but it's definitely a live issue in quite a number of the cases we're dealing with at the minute.
Thank you. Thank you, Deputy Chair. Look, just in conclusion, one sort of final question from me, which I didn't get to ask you earlier. Well, two very quick ones. What are the actual urgent circumstances in which a minister may make a TEO that would come into force immediately? That's one question. And then the second question, probably for the AFP again, have you asked government for any additional provisions allowing service of a return permit by additional means, say by text or email, or on the individual in person upon their arrival into Australia, where all other means, including email and text, have been exhausted? And how operationally would that actually, how would service of a return permit by text, email or in person actually work?
So I think on the second question first, I mentioned before we use whatever is the best contact information we have, whether that's a representative or so it. While I said we might write a letter, the letters are customarily emailed rather than dropped in the post if we have a if we have an email address.
It's an electronic letter, right?
Yeah,
Yep,
and sorry, could you just repeat your first question? Sorry,
well, that question was really, have you asked government for any additional provision allowing service of a return permit by text or email?
Yeah. So as a matter of practice, we have used that.
Okay, right. Okay, and the first question, going back to that, was what would be the urgent circumstances in which a minister may make a TEO that comes into force immediately?
Probably the best example I could give of that was the urgency could well be the impending travel. So if we received information that a person of CT concern was looking to travel to Australia next week, then and needing to go through those processes of preparation that we've described this afternoon, that could be one where the process of waiting for the review process is the minister makes a decision that no, we'll put it into place immediately in the interest of protecting the community, and then go through the process of review subsequently.
Right. No, thank you, Mr. Curvin. Okay, so if there are no other questions from colleagues, I do want to thank all of you for your attendance today. It's much appreciated. If you have been asked to provide any additional information, I think there was a couple, 3 or 4 requests there that have been acknowledged. Could you please forward that additional information to the Secretariat by 4 p.m. on Monday, the 24th of October this year? I have to say that because some people might think it's next year. You'll all be sent a copy of the transcript of your evidence, and of course we'll have an opportunity to request corrections to any transcription errors if there are any. So once again, thank you all for your attendance today. Much appreciated. And I think we'll see some of you next week as well. So thanks very much.
Thank you, Chair. Thanks, Committee.
Thank you. Colleagues, there being no further witnesses, I declare this public hearing closed. I just would remind all of us that you should log out of WebEx and then log back, because we're not conducting the next session at 3 o'clock on WebEx. We're doing it on Teams. So if you log out of this WebEx, please do so that you could log into Teams for the 3 o'clock private hearing with the various organisations on the impacts of the listing of Hamas.